One mention. My lord, I have one mention. In item 5, we have filed an dusty service affidavit. It is not on record. We may be allowed to bring on record. That the matter may be taken at 2 p.m. Item 5.
Yes.
So we may be allowed to bring the same on record. And matter may be taken at 2 p.m. because
At 2.
because it may not come before 5. Before item 5, it may not come. That's why, my lord, I am bringing.
Item 5 is on the death of.
And regarding conversation matter, they are regarding we serve
Which-
notice to
Which
justice service.
item are you talking about?
Item 5 to this list.
Item 5, today's list.
Program so limited.
Mangali ji, call the affidavit. We'll get the affidavit, don't worry. Yes,
Yeah, please, your lordship. I beg to mention item number 28. Lordship, my senior is not well, so kindly please fix the matter after 1 week.
when council MS so submits that senior counsel, the lead counsel, Mr. So is not available today. The writ petition, writ appeal of 2019, madam. Why adjournment is being sought? What is it listed for? Orders,
No, your lordship. It is
Hearing.
for hearing matter.
all right.
Yeah.
List after 4 weeks as per it.
28, 27 and 28.
28,
27 and 28.
27 and 28, 4 weeks.
May I please, your lordship?
Yes.
Lordship, item number 23, your lordship.
Yes,
Your lordship, my senior Anand Karmakar has expired, your lordship. So sometime may be granted to get
It is-
action from appellant.
and counsel, Mr. Karmakar, who represented the appellant in this appeal, has passed away. His associate counsel, Mr. So-and-so, placed for time to complete his instructions regarding appearance on behalf of the appellant. List of 4 weeks.
Deeply uplifted.
May I please, your lordship? Lordship, with the consent of the other side, I pray for item number 14. It may be taken up anytime on next week, lordship. Only for the day I am praying for adjournment.
You are appearing on behalf of
I am for the respondents, lordship.
and counsel appearing for the respondents. Placed for time, list of 4 weeks.
Lordship, it is in the part 2 list otherwise.
4 weeks.
Much appreciated, lordship.
May I please, your lordship?
Yes,
Lordship, I beg to mention item 7 of deferred one list.
yes.
Lordship, this bench may not like to take up this matter.
This before a bench of which Honorable Justice Suman Shah is not a member.
Deeply obliged.
May I please, Lord?
6 and 7.
Item number, my lord, 21 and 22,
Yes,
my lord, with the consent of the other side, my lord. We would like to, my lord, take some accommodation, my lord. Can it be listed in the next week, my lord?
and counsel appearing for the
Appellant, my lord.
appellant oblique writ petitioner, comma. Place for time, list of 4 weeks.
Deep law, please.
Yes,
Lordship, with regard to item number 8 to 11, your lordship, probably this court will not like to pick up this matter, lordship. 8 to 11, your lordship.
yes,
The judgment is by on
Other bench
other bench, no,
from 2, the bench from 2.
lordship, 8 to 11 of this bench, your lordship.
yes. What do you want?
Lordship, that matter will perhaps not be like taken up by Justice
देखते हैं।
Shami, lordship.
Is it your order?
11.
Is it the order passed by lordship? List before a bench of which Justice Suman Shah is not a member. Division bench.
May it please, your lordship? Lordship, I have a prayer in respect of the green bench matter, my lord. My lord, I have to call for records in one of the matters, that is item number 7 of the green bench, my lord. Your
Yes.
come right. Lord, may I be allowed to call that records for, that is an IA, my lord. For
Let it be taken up, we'll see.
Hello.
Let it be taken up.
Maybe, highly obliged.
Yes.
Wait, please, your lordships, my lord, item 6 of today's list, I'm told by the other side, I appear for the respondents in this matter.
This has already been adjourned.
My
No,
lord,
6.
6,
you're
my
not-
lord,
yes.
My lord,
6 and 7 already adjourned.
my lord,
The other side made a request. Exception,
My lord, if a
it's
date.
it's an exception of my lord, Justice
Yes, my
Suman.
lord, if a my prayers, my lord, if a date may please be fixed.
Date maybe in May first week. First week of May.
Obliged.
Date दे दीजिए. 8th May. Yes.
Item number 31 of supplementary list for motion.
May I please, Lordship? My lord, in this case, my lord, at page 37, my minor correction is there, my lord.
Mm,
Some typographical mistake is there, my lord.
Yes.
Page 37. My lord.
Mm.
So, my lord, I may be allowed to rectify.
What is the writ petition, the appeal about?
No,
A
my
writ
lord,
petition.
petition, my lord.
Mhm.
Yes. Against the sir.
Why don't you go to DRT?
Yes, no, my lord, I already.
You've been there. The order of the DRT is challenged.
Order not passed, my lord. Kindly see page 39, my lord. And except C, my lord. In the meantime, my lord, the auction notice, auction sale notice has been issued, my lord.
Mm.
Page 38, my lord.
Yesterday we were told DRT is
Yes.
not
Not today. at least.
presently available.
Yes.
So then we'll accommodate them for a week. Then the DRT holds sitting, they can prosecute their cause.
Only for a week then because the.
Of course.
Surface, I may.
What do you say?
Lordships may allow the auction to proceed, but confirmation.
Sale will not be confirmed.
My lord, I'm paying for some time, my lord, to 6 months time. My lord.
Why?
Is ready to
That
pay.
you have to go to DRT and plead, sir.
My lord, I have already filed, my lord, the
So all right, DRT will take up your application.
yes, my lord.
DRT will,
Till then, my lord, some protection.
we can pass an order that till the DRT
Yes, my lord.
takes up the application,
Okay.
the sale will not be finalized.
Gotcha.
Okay.
The auction may proceed, that's it.
Mr. Arif Chauhan, learned counsel for the petitioner submits that although an application under section 17 of the DRT Act of the Surface Act 2002 has been filed on behalf of his client seeking an interim order of stay of the auction sale. Yet due to non-availability of the presiding officer of the DRT, the application has not been taken up for consideration. Due to the full stop. Mr. A. Ganguly, learned counsel, is present on behalf of the bank and submits that the auction sale may be permitted to proceed, but it will not be confirmed until the next day. In view of the above, let this matter be listed again.
We'll dispose it of, say, can be disposed, the DRT will take up the application expeditiously. Until that time, the auction sale will not be
In view of
finalized.
the above, without expressing any opinion on the merit of the claims and counterclaims of the parties, we dispose of the petition by providing that the learned DIT may take up the application filed by the petitioner under section 17 of the Act of 2002 on merit until such time an order is passed in that application. The respondent bank shall not confirm the sale.
Okay.
Auction sale.
Obliged.
Item number 1 of daily list.
May it please your lordship. I'm sorry to mention, my lord, that I misplaced the file, my lord. So for last 2 days, I could not trace it. So whether if your lordship kindly permit me to photocopy the.
Ex parte order.
And
What is the order, sir?
The order is of status quo.
And
my lord,
matter may
it's
fix on
surface
Tuesday
matter.
or Thursday, my lord.
Surface.
Surface matter, and that is still since 22 June 2022, my lords. In fact, my lord, if one sees the record, my lord, the order has not been extended after that. day.
Okay. We'll give her 2 days time to reconstruct the file. And counsel Ms.
Next
states
to any day, my lord.
that her original record has been misplaced and she needs short opportunity to reconstruct the file. Re-notify on Monday.
Monday, my lord, Tuesday or Thursday, my lord.
You give her the file today itself. Give her a copy.
Um,
Monday.
Item numbers 2 and 3.
Yes,
May it please your lordship. This matter pertains to demolition of a residential building, your lordship.
yes.
Your lordship, factual background of the case is that judgment was passed by the learned single judge of this honorable court. The judgment is at page 102, your lordship. (103), the order starts, your lordship. If I may read, your lordship.
Yes.
At page 103, the last sentence is important, your lordship. In fact, on the last occasion also, that is on so and so, none has appeared for the said respondent number 5, and this court have made an observation that in case of further default by the said respondent, number 5, appropriate orders will be placed. I was respondent number 5 in that writ proceeding, your lordship. Then at page 104, your lordship. The subject matter of
Writ
this
was filed by whom?
lordship.
Who was the petitioner? Who is the petitioner?
Petitioner was the respondent number 6 here in your lordship. He is my neighbor, your.
He's your neighbor. He filed the writ,
Yes, your.
paying for demolition of your house.
Yes, your. Then at page 104, your lordship.
Is the complaint?
Yes.
Not directly.
Then he has to put in municipal authorities if he is a neighbor. And if he has a grievance against his neighbor, or else he can file civil suit. Beyond that, let's take it direct. Proceed as per law. Demolition direct. The private dispute resolution.
The third paragraph at page 104, your lordship.
Yes.
City so and so, the Lana State Council, by referring to the instruction dated so and so, which accompanies the field verification report,
Yes.
submits that the averments and allegation of the petitioner are substantially correct. In fact, the field verification report, the deviations have been specifically mentioned. In view of the clear finding, which till now have not been challenged by the affected respondent number 5, the respondent authorities, namely so and so, are directed to take appropriate steps and action in accordance with law by noting the deviations found and recorded in the field verification report.
Yes.
So the field verification report was prepared on the basis of a judicial order passed by this honorable court, your lordship. And that field verification report is important, your lordship. That is at page 91, your lordship. But before that, if your lordship may kindly come to page 90. After this, after order passed by the learned single judge, your lordship, the Tinsukia Municipal Board on 25/3/2022 at page 90, your lordship,
Yes.
issued this order in pursuance to Honorable High Court order dated so and so, in case of so and so, wherein the Honorable High Court has directed the Tinsukia Municipal Board to undertake joint verification, site verification of the building constructed by so and so. The following team is hereby detailed to conduct the assessment. The
Yes.
lordship will find that there are 4 persons.
Hmm.
1, 2, 3, and 4, serial number 1. And then your lordship, this team did the field verification where I was also present. And that
Yes.
field verification report is at page 91, your lordship.
Hmm.
If your lordship will may kindly come to the signature portion at
Yes.
the bottom, your lordship, only one of the members signed. That is at page 90, serial number.
But there is no objection by you
Yes, your lordship, because I couldn't appear. That is my
Where?
only fault, your lordship.
in the field verification.
No, I feel in the field verification I appeared.
Then
when the
there
field
is
verification
no
was submitted-
objection from your side.
I objected, your lordship. That is also there. That
Where
is also there.
Where is it?
Again,
There are two
at
officers.
page 97, I have given a detailed objection regarding this. But I could not challenge it before this honorable court because I was not present, your lordship, on 2 occasions, your lordship. That is my fault. I admit that, your lordship. And I have submitted all the medical reports as to why I could not give my instruction to the Planet Council who appeared on my behalf, your lordship. But that's a different aspect, your lordship. I have challenged this field verification report later by way of writ petition, your lordship.
Now the point is, you told her David.
They are calling upon your direction for this block backward law. That is what the direction is from. They have my numbers. Uncontested, uncontested. And that is why I'm saying it can be the money. Set order that it is maybe for whatever it is. Since it is a matter of property rights.
So he says he was not heard in the field verification.
No, field verification is also. Your client were present in the field verification.
Yes, Your Honor.
But he did not mark his objection.
He did. That is why the other members. Did
Where
not
is
sign.
it?
That is my pleaded case, Your Lordship. The other members did not sign the field verification report. Because this field verification report was was faulty on the ground that you, Your Lordship. may
What is
kindly
the
come to
stand
page
of the
92,
municipal authorities in the appeal?
Your Lordship.
What do the municipal authorities say in the appeal?
In the appeal, they have not said. Your Lordship may kindly come to page 92 also.
Yes,
5 minutes, I'll take Your Lordship.
yes.
Page 92, that is an part of the field verification report, Your Lordship.
Hmm.
There are two drawings of the map of the residential structure is given, Your Lordship.
Yes.
On the upper side, it is a drawing which was of 2011 when my
Hmm.
permission was granted.
Hmm.
On the southern side, that is on the top part, Your Lordship,
Yes.
the shape of the land, as Your Lordship will find, is different from the drawing on the lower side, that is of 2022.
Yes.
So my entire case is that there was no deviation from my side. The deviation was found in the field verification because there was encroachment of my land on my southern side.
Hmm.
And that encroachment was done by him. The respondent number 6 was the petitioner, Your Lordship.
This is a purely a
my
civil
entire case.
dispute.
Yes, Your Lordship.
Yes, who
That is-
represents the red
Yes,
petitioner?
that I have gone. That I have started, initiated different proceeding for them. But there was no.
Just
deviation,
hold
Your
on.
Lordship.
Who is for the red petitioner?
I'm for the writ petition.
Why this writ was to be entertained? Will let us know. Go file a suit.
My
Yes, Your
thing is that, my lord, so far this dispute of the land is concerned, my lord, this is separate issue.
Yes.
Question about.
Why the writ court is supposed to act intercept between property dispute of two people?
Absolutely,
Yes,
quite
sir.
right, my lord. There is no dispute about the land, my lord. Question is the lord, just look for a moment.
We are not at all looking, sir.
Absolutely, my lord.
Absolutely no.
Quite right,
We,
my lord.
we just don't approve this.
My lord, setback, my lord, kindly see, suppose. one-
This is not for the red court to see. We'll go around checking the setback of every building in Guwahati.
Your Lordship.
My lord, Civil code is, my lord, no doubt entertain the disputed text, my lord.
Yes.
That, my lord, here is a case, my lord. In addition to that, my lord, the authority has found certain violation in regard to the building to other side also, my lord.
Appeal allowed visas to follow.
My lord, kindly see for a moment.
Yes,
Okay.
we'll make comments, strictures against the petitioner. He could not have approached the red court. You want us, we'll get his construction verified. We'll do so. Any encroachment, it will be removed forthwith. You want that direction? We can give it.
My lord, so far,
This is too much. How could a writ have been entertained on these allegations?
my
This is
lord,
too much. Misuse of process.
my lord, we have.
All right, you argue.
My lord, no, my lord,
Complete,
no,
please.
no problem, my lord.
Carry on, sir. Yes, we'll take note of our arguments. Yes, please.
My lord, so far the dispute is concerned, my lord, I will not go to that side, but simple saying that if any allegations. my
Mr.
lord,
Counsel, as an officer of the court, let us know.
Right.
Was this writ to be entertained?
My lord, we leave to your lordship that if lordship find that there is no scope.
You let us know. This is a private dispute between two neighbors.
My lord,
The civil courts are there for that purpose.
My lord.
Why a red court is supposed to intervene? It's really too much. Straight off, we should have relegated you to go to the civil court. The civil court should then be wound up.
My lord.
Because if writ court is supposed to do all these things,
My lord.
then we don't need civil courts in this state. What for are the district courts and the civil judges working?
Lordship, kindly permit me only 1 minute, my lord.
All right, carry on. Yes,
My lord, thing is that, my lord, so far the land dispute is concerned, my lord, this is separate zone, my lord. Here is a case, my lord, a violation we have detected which
Yes.
is inconvenience to us.
you are representing
My
the
lord.
writ petitioner.
Yes, my lord. Complaint.
You have not detected the violation. The job of detecting violation is with the municipality.
Exactly, they have found, my lord. The detection has been found by the authority. We have only,
On directions of this court.
first we have approached before the authority, put our complaint, that has not been entertained.
Then
Therefore,
you
we
straight off come to the red court.
Then, my lord, seeking, my lord, certain direction, we approach before this honorable court.
Or a private party, your neighbor.
My lord, might be, but is it a case, my lord, that never cannot be do any fault, my lord? If suppose he had carried out illegal construction, my lord,
All right. Very well.
that
Yes.
allegation, my lord, we have leveled before the authority and
Yes.
authority has entertained our, they didn't entertain our application. That's why we approached before this honorable court, my lord.
Yes.
And after approaching this honorable court, my lord, a direction was given in presence of the both party for field
Yes.
verification.
Yes.
Now report is lordship kindly.
Presence of both parties.
Exactly, my lord. Now, in presence of the both party, and he himself admitted, my lord, kindly see his admission, my lord. Just look for a moment, only one line I would like to show much.
Yes. Is there a provision for compounding?
Yes, your
Yes, provision is also there, my lord.
Yes, your.
Lordship, kindly see his own representation. Where he
Mr.
is
Counsel. Mr. Counsel,
106, my lord. Hold
is
on.
there a provision for compounding?
Yes, my lord. My lord,
Does the
provision,
report leave room for that
my lord, he
exercise?
For appeal under section 321 of the, my lord, Assam Municipal Act 1956.
Against the single bench order?
No, my lord. Against, my lord, the violation which has been found by the board.
Mr. Counsel, the board doesn't take any action. Why is he supposed to go there?
He himself admitted paid 106.1. Only see for one line, my lord. 106. He himself admitted, my lord, violation. Page 106, second paragraph. I hereby state
Sir,
that
we reiterate the question. Is there a provision of compounding?
compounding is.
What happens to that provision? What happens to that jurisdiction?
It is his
after the
duty
writ
to
court?
approach before the authority, my lord. He has not filed any application before the appellate authority, my lord.
Why he should do so? Authority doesn't give him any notice that we are acting against the violation.
My lord, Section 3, may I read, my lord, section 321? For
Yes,
What
please.
it says so.
Yes. Yes.
Appeal from order of board, section 321. Any person aggrieved, D, any order made by the board under the powers conferred upon it by section 181 or section 255.
Yes.
Under this provision, they can approach before the appellate authority. Now, section 181 says building unfit for human habitation.
Yes.
Should a building or a room in a building be, in opinion of the board, unfit for human habitation in consequences of the want of proper means of drainage or ventilation, otherwise,
Yes.
the board by notice forbid the owner or occupier thereof from using the building or room for human habitation. Now, this provision, my lord, if suppose under which a notice has been issued to them, which they have not complied with, my lord. Therefore, my lord, the findings is that, my lord, certain violation that has been found, and he himself admitted, page 106. Therefore, I request you to grant me 10 days time for demolishing the deviation. He himself admitted, my lord.
Yes.
Once he himself admitted, now how he can say, my lord, there is certain dispute in regard to land, etc., taking the seal of that, my lord. And lordship, kindly see, I hereby state that the time sought to demolish the deviation is for the purpose of calculating the compoundable deviation and then demolishing and not for approaching any court. Now, second line, therefore, I request you to grant me 10 days time for demolishing the deviation stated in the letter.
Was there any scope with the authority after the direction of this court to entertain any compounding application?
My lord, the question is that, my lord, a finding.
You don't pose questions to the court firstly.
My lord,
You don't pose questions to the court.
absolutely.
It's the court's domain.
Sorry, yeah, absolutely,
We have put your question.
absolutely.
Is there any jurisdiction vested in the authority after this court's order to entertain such an application?
Yes, my lord. That is, I would like to make clear, my lord.
Yes.
If verification report was done, and based on that, my lord, this honorable court directed to suppose do the needful, my lord.
Yes.
And therefore, my lord, they have issued a demolition notice. Now, this demolition notice, they can challenge, my lord, under section 321, my lord, appellate authority, which they have never done. Instead of they are saying that we need 10 days time for.
This is the third time we are posing the question to you. It's your choice to answer or not. After the direction of the writ court that the authorities will act as per the FVC, is there any discretion left to compound?
In my view, my lord, section 321 apply, my lord.
Okay, very well. Appeal allowed. Order set aside.
Highly obliged, your lord.
There are
Number
two
32 of
appeals.
My lord, there are two orders they have stood on the table.
Review.
That's not required.
Keep your, obliged. your.
item number 32 of supplementary list for admission.
Yes,
please, your lordship.
yes,
My lord, on last occasion, lordship was pleased to direct the state authority.
yes. Please have a look at that order.
Yes,
You have a copy?
yes, I've been given a copy.
Anything left now?
No, my lord, the question is,
Confiscation, sir,
no,
which is never challenged.
no, what I'm trying to say is, my lord, even my lord, the report also speaks about 55%.
It's an order of confiscation.
True.
Report, which report are you? Rupam, yesterday they gave that order.
No,
Where is
no,
it?
I've been given a copy, my lord.
Just, we want to see, we've, you made an index.
Yes.
Yes,
If your lordship would kindly come to my lord, paragraph 10,
yes.
in view of the above conclusion, even without going into details,
Hmm.
above legality of felling order issued by forest department from so-called garden area,
Yes,
and whether Sri F.U. Chaudhary was directly involved into various irregularities or illegalities, as the timber detained at Boirabi railway yard has been felled in violation of the Supreme Court's order, it is liable for confiscation. Further, as the details of the timber do not tally with the detail mentioned in the transit pass, it is therefore to be treated as illegal timber and is liable to be confiscated on this count also. In
Yes.
addition, as more than 50% of the timber.
That is
has
in
been felled
addition.
from-
that is in addition. So it makes the
In-
entire bulk.
In that case, lordships will reserve our liberty to challenge the confiscation order, and delay aspect may be, my lord, considered, because this order was never given to us, my lord.
You are present. You are present.
Yes, but
So,
no, regarding the order, my lord.
yes, but you are present.
No, my lord, this order was never communicated to us.
It's not your case. It's not your case. It's only when we pose the query that this order came forth.
Yes.
Sure.
No, lordship.
That was
is-
a
That way lordship. is
Natural
correct, my lord.
query, Mr. Chaudhary.
Yes,
That was a natural query
yes,
to find out whether any order of confiscation was passed or not. So,
true, my lord. Our client from their side, they could not, my lord, lay their hands to it.
all right. Okay.
One second, my lord.
Yes,
এখন challenge করবো না, my lord. But my lord, only one aspect, if your lordship will kindly consider, but I could follow what has followed from your lordships. Now, this order is dated, my lord, apparently 17/5/2002.
yes,
Now, the Supreme Court's interim, Supreme Court's order is prior to that.
yes, they have taken note of that order.
My lord, at page 56, my lord.
Yes. This order may be illegal,
Yes,
maybe presuming that this order is illegal,
yes.
but it has the
But it
sanction
is
of
now.
law.
End of the day, there is an order.
Yes.
No, only thing I was, my lord, but the delay aspect would come in.
We would take your chances if delay can be controlled or
If
not.
your lordship would make an observation, it will be,
We don't know whether the order was communicated or not. It's only because we put the query that it is brought on record of these proceedings.
no, lordship will make an observation that it will be open, if otherwise it is permissible not to challenge the
All
order of
right,
confiscation, my lord.
okay. In furtherance of the order dated so and so, their case is, please allow us to challenge this order now.
Lordship, that can be.
No, but we are not condoning delay.
They were aware of, I mean, in
True.
2012. A copy was given.
In view of the order of confiscation dated 30th April 2002 oblique 17 May 2002, placed on record by Mr. Kalita, Shri K.N. Chaudhary, Senior Counsel, representing the appellant, craves liberty to withdraw the instant appeal, seeking leave that the appellant may be permitted to challenge the said order of confiscation as per by invoking the appropriate remedy. Shri Kalita does not object to the said submission, thus, the instant rate appeal is disposed of as withdrawn with the liberty prayed for. Okay.
Item number 4 of daily list for orders.
Yes.
May I please, your lordship?
Yes,
The payment deposit will be made by today.
it has been deposited.
Will be depositing today. We'll be
Okay.
depositing today. And then
The-
will be estimate.
Then counsel, Mr. Kalsi submits that the petitioner is prepared to deposit peremptory cost in terms of the order dated 13/3/2023 let the cost be deposited within 7 days. The receipt of deposit of cost be annexed with the file and the matter be listed on 2nd May, 2nd April, 3rd April. Yes.
Item number 5,
Yes.
Your Lordship, for equation of the of dusty service affidavit, the
Mm.
matter may be taken at 2.
At
2.
2. Why?
Uh, For dusty service. in
Okay,
one
this
it was
one.
Mentioned.
It's yet to come. Pass over, call the affidavit right now.
Obligation.
We are passing it over for the timing. Yes.
item number 12 for hearing.
May it please the Lordship. My lord, the petitioner, the appellant before Lordships, my lord, was selected by a selection committee for the post of assistant professor of in Boro language in Bizni College, my lord. Now, my lord, that selection, which was eventually approved by the director, my lord, competent authority, was challenged before the learned single judge. And the learned single judge, my lord, interfered
All
with
parties
this.
are present, all respondents.
Wait a minute, President.
Who is for the BDC?
Responded to one.
He represents the writ petitioner, my lord.
Mhm.
Otherwise, state is the party.
Okay.
Basically, it was the writ petitioner whose writ petition was allowed.
Very well.
Yes.
Who is for the BTC?
So Lordship would kindly come to my lord. Page number 52, my lord.
Yes. What is this earlier order of division bench? 16/8/19?
Yes, my lord, this honorable court directed, actually, basically, we filed an affidavit pursuant to the order to show that that relevant point of time, I was working on contract basis in the same very college, my lord.
Okay.
And because the issue is regarding the experience.
Mhm.
Yes. Now, Lordship will kindly come to page 63, my lord. This is the office memorandum which lays down the guideline for selection of assistant professor at page 63. 14th of August 2015, my lord. Guideline for selection of assistant professor, distribution of marks for ranking candidates.
Archana Sharma said some other judgment which has been placed. Citation, actually. Yes.
If your lordship would kindly come to page 64, number 3, my lord, that is the issue.
64.
Page 64, para 3, my lord. Serial number 3.
Hold on, please. Yes.
Teaching
Yes.
experience shall carry 2 marks for 1 year of experience of teaching undergraduate in the state government recognized college, subject to a maximum of 10 marks. This will be related to actual total hours of teaching imparted by the candidate in the particular year with the standard teaching hours of a regular assistant professor as per UGC guidelines. Further, teaching experience shall be counted only for those candidates and to such extent only who have taught the concerned subject after acquiring the eligibility conditions. So, my lord, basically the issue which falls for consideration is, my lord, on account of this head, I was given 8 marks. The writ petitioner would like to contend that I was eligible for 6 marks, not 8 marks. And our case was, my lord, actually I was eligible for 10 marks, but I was given 8 marks. Of course, that 2 marks makes a difference between when it count the, my lord, aggregate mark of both the candidates. Now, my lord will kindly come to page number 10, page number 53, my lord, 52. What was the case of the writ petitioner before the learned single judge?
Yes.
Para 15. Earlier, my lord, they lodged some complaint. Based on that, a writ petition was filed. Then learned single judge gave a direction that director will consider the case in accordance with the guidelines. That the petitioner begs to submit that the Director of Education BTC failed to take into consideration the contention of the petitioner made in WPC number so and so, and his representation dated 4/2/17, and documents annexed here to more specifically that the UGC norms and guidelines that bar a junior research fellowship scholar from taking any other employment or job during his or undergoing the junior research fellowship, a scholar for a period of 2 years, and therefore the period of LS service of respondent number 10, that is the appellant, in Business College with effect from 27/8/13 for 2 years is not countable as her work experience. And so she is only entitled to 2 into 3 years, that is 6 marks in teaching experience instead of 8 marks given by the selection committee for her period of 3 years, 16 days service at Business College, apart from illegally giving higher marks under the head teaching skill and also in oral interview, and even full marks by some other members without reasoning as required under clause 8 of the guidelines dated so and so. So this was the case, my lord. Then, my lord, Lordship will kindly take note of our case, my lord. Now, please come to page 104, my lord. This is the joining report pursuant to that award of junior fellowship in favor of the appellant. Asarani Brahma National Eligibility Test date so and so. This is to certify that Asarani Brahma has joined the Department of Boro, Bodoland University, Kokrajhar, for doing MPhil PhD under the scheme of the University Grants Commission with effect from 27/8/13. He shall be, etc., etc. So this is a document to show, my lord, with effect from 27/8/13, the appellant joined as a research fellow for doing her PhD, my lord. Then, my lord, in our affidavit, we dealt with the contention of the petitioner, my lord. Affidavit my lord will kindly come to my lord, page 176.
166.
176. my lord.
76.
The stand of the appellant before the learned single judge. 149 to PSC, yes? 149 to PSC.
Yes.
Yes. That the main contention of the writ petitioner is that
There are
that the
4.
respondent number 10, has
Yes.
also got it, my lord.
Yes.
That the main contention of the writ petitioner is that the respondent number 10 has got the teaching experience of only 3 years and 16 days with effect from 10/8/2010 to 26/8/2013, as she joined the Department of Bodoland University on 27/8/13 as junior research fellow, and her experience after 27/8/13 is not countable as the UGC norms and guidelines bar a JRF from taking any other employment or job during his or her undergoing JRF. The contention is untenable in as much as there is no provision of law debarring college authority from counting the teaching experience of the deponent gathered during JRF period.
All that.
If the deponent is found to have been doing JRF in violation of the UGC norms and guidelines, the JRF is liable to be terminated by the university,
Yes.
but the experience gathered by the department is not liable to be wiped out. Moreover, it is the Department of University which may have objection for doing teaching on contractual basis during the JRF period. But when the department has no objection, the other person has no locus standi to raise the issue. The petitioner and the department are doing the teaching job on contractual basis in the same college, and petitioner was fully aware of the fact that deponent continued her teaching after joining JRF on 27/8/13, but she never raised any objection before any authority. If the deponent was doing the teaching in violation of UGC norms and guidelines, she ought to have brought this fact to the notice of the concerned college, but she remained silent, and deponent, after being selected for the post of assistant professor in the college. She raised the issue with a malafide intention. The petitioner in fact misconceived the provision of law and filed the instant writ petition, which is liable to be rejected. So our case was very simple, my lord. Yes, I was undergoing that JRF thing, but at the same time, I was also doing a contractual job, that too with the permission of the university, my lord. Now, I'll just show that, my lord. If your lordship would kindly come to page 186, my lord.
Yes.
Yes, it is by the head of the Department of Borough.
Mm.
This is to certify that Asarani Brahma, that is the appellant, is a regular research scholar in the Department of Borough, Boroland University of Kokrajhar, and the academic department has no objection if she is involved in teaching as contractual course teacher in the academic institution.
Okay.
So, my lord, with the permission of the university itself, I was.
But
doing
this
that.
is of 16.
Yes, my lord.
The period, contemporaneous period is 2000.
Prior to that,
So how does this permission help you?
my lord.
How does this permission help you?
No, my lord, this is the stand of the author, my lord, because all these things happened when the complaints were started coming, my lord. My lord, actually what had happened prior to, while the selection process was going on, that writ petition was filed. Where this honorable court said, Ladi Singhal just said, that the director will take on board all the complaint, all the provisions, then take a call. Now, eventually, my lord, the approval was given in my favor, and that teaching experience was counted. Now, my lord will kindly come to page number 149, my lord. 149 pages. Oh. 149 is the order where this honorable court directed that the authorities should take a call at. Operative portion is at 153.
Yes.
Para 8, my lord. That being the position, the governing body of Bizni College may consider the proceedings of the selection committee held on 24/2/16, including the objection raised by the petitioner, and thereafter to take a decision whether to make a recommendation to the director of the higher education or not. Both the governing body of the Bizni College and director of higher education Assam may take an appropriate decision under Rule 5 and 7 of the Assam College Employees Provincialization Rules 2010 in accordance with law. Keeping in mind the discussion made above within a reasonable period to enable governing body and director education to take an appropriate decision, interim order would stand vacated. My lord, pursuant to this order, my lord, the order was passed, which your lordship will get at page 176. Sorry, 170. Yes, 174, my lord. Yeah. 174, my lord. This was the order which was challenged before the Ladi Singhal judge. Page 174.
Yes.
I'm reading from the first subpara, my lord.
Yes.
Or second subpara. The petitioner Binika Goyari MA, who appeared in the same interview on 24/2/16, and she filed the writ petition in the Honorable Guwahati High Court, challenging the selection of candidate against this post. She complained that Asarani Brahma joined as a regular scholar in PhD program at JRF with effect from 27/8/13 for the session 13/14, and doing her research under the supervision of Dr. Indira Boro, faculty member of the Department of Boroland University. So her teaching experience is 3 years. It is contended that under the head teaching experience, respondent number 6 was allotted 8 marks instead of 6 marks. Both of them were awarded 2 marks per year by the members of the selection committee. Further, also read and perused the resolution number 2 of the governing body meeting held on 17th of February 2017, and report of the principal. It is stated that Asarani Brahma has been regularly attending college during JRF period. The selection committee don't know about her doing JRF. Binika Goyari also have not denied that respondent Asarani Brahma have been regular in teaching, attending college during JRF period. Mrs. Asarani Brahma have been working in the post of assistant professor of Borough Department on contractual basis in the Bijni College continuously from 10/8/2010. Also peruse the learned opinion of the so-and-so of the Guwahati High Court, who has advised to approve the respondent number 6 for appointment in the post of the assistant professor in the Department of Borough of Bijni College. Consequent upon the above fact and circumstances, it is affirmed that Asarani Brahmo, respondent number 6, is duly selected by the selection committee, and governing body of the college also recommended that the said candidate as per the provisions of rules and procedure. As such, the proposal along with necessary particulars may be forwarded to the BTC authority for necessary administrative approval for appointment of the said candidate. With this honorable court's order, dated stand this for your.
Should not have.
It can be given credit for.
Assuming that it doesn't indicate. GRM. Not a.
That's what they.
Not selected in front of it, isn't it?
That the only.
এখন তো 2018 না কইছে
Any emoluments paid or other. Might be getting some financial. She has done some pension. By doing that, which has been this issue. Maybe use this to cancel this because she has reached the money.
That's one part.
Experience.
Yeah, I get it.
Yes.
My lord, the petitioner's case before the learned single judge was, since during that relevant time, I was a research scholar.
Yes.
Therefore, that cannot be counted towards my teaching experience. But single judge has gone beyond that. Single judge has, decided the issue from a different perspective altogether. Please come to page 228.
Yes.
Single judge has decided from this perspective, my lord.
228.
Yes. Now, there is no dispute that at the same time, I was also doing my contractual job.
That is
as
an
a-
admitted position.
Yes,
Yes.
page 228. 3.9.0, this is, my lord, that UGC regulation.
Hmm.
Period of time taken by candidates to acquire MPhil or PhD shall not be considered as teaching research experience to be claimed for appointment. Well, this is not our case because in our affidavit of opposition, we have already stated, neither it is the case of the college authority. The single judge decided from this perspective. Whereas, my lord, it is the stated stand of the government of Assam that UGC regulation has not been adopted by the state. And
Has not been.
yes, my lord. And in fact, my lord, not only 1, 2, 3 cases, the Advocate General appeared, I brought those judgments.
What
So
was the
single
question?
judge,
What was the question in this case?
no, no.
In
the-
your case, what did the state of Assam,
No,
please.
in this case, that, the position did not emerge, my lord, but
is that an argument
Huh.
before the writ court?
before the lead code, government. Government, my lord, the government's submission as such is not recorded, my lord.
Hmm, hmm.
Private respondent. Now, let me place it, then I'll make the submission, my lord.
Hmm.
Please come to page 228. Then after quoting 3.9.0, the contents of UGC regulation of the guidelines given in government OM stated above, particularly at para 3 of the same, makes it clear beyond doubt that period of teaching undertaken by candidate while pursuing research would not be counted for teaching experience for the purpose of appointment to the post of the assistant professor.
Mm.
There is no denying the fact that respondent number 10 got herself admitted to JRF from 27/8/13 and was still continuing her PhD degree when the interview was held in 2016. Therefore, the period of her teaching experience which has to be counted is from 2010 to 2013 only, and for that she was entitled to get 6 marks. That is 2 into 3 is equal to 6. This shows that selection committee had committed an error by allotting 8 marks instead of 6 marks by the members. Now, this is important. As stated by the Honorable Supreme Court, in the case cited by the Learned Council for UGSC, UGC Act is mandatory for all universities and colleges and both open and formal. Therefore, rules or regulations framed under it are mandatory, needs no further discussion. So, my lord, the learned single judge's basic reasoning flows from the understanding that UGC circular is mandatory. My lord, it is mandatory for central universities. For state university, it is not mandatory unless it is adopted.
Bottom 4 lines.
It is obligatory on the part of the to follow the same. No, my lord, this is what has been negated. Moreover, the fact of the office memorandum which was notified by the government was applied and followed in the selection process shows that UGC regulations are followed in the state of Assam. No, my lord. This is absolutely incorrect, my lord. Because I'll show 2 judgments of 2 division bench, my lord, where I made this argument which was negated by this court because state came up with the plea that we have not adopted, my lord, UGC regulation. I think my learned friend is also aware of that. So, my lord, this circle, now let us go to this 14.8.15 circular, my lord. It does not speak of UGC regulation, my lord. It speaks of teaching experience only. Page 63, 63, no?
How natural it is to fall back onto vernacular language. Many times I am prompted to use Hindi, but unfortunately I can't.
Kindly come to page 64, my lord.
Yes.
Page 3. Teaching experience shall carry 2 marks for 1 year of
64.
experience.
Just
I'm
64.
sorry, my lord. Page 64.
Yes.
Teaching experience shall carry 2 marks for 1 year of experience of teaching undergraduates in the state government recognized colleges subject to maximum 10 marks.
Yes.
This will be related to actual total hours of teaching imparted by the candidates in particular year with the standard teaching hour of a regular assistant professor as per UGC guidelines. Further, teaching experience shall be counted only for those candidates and to such extent only who have taught the concerned subject after acquiring the eligibility for the conditions. So it is not the case of the writ petitioner that, my lord, I didn't have the eligibility. I had
Yes.
the eligibility, my lord.
Yes.
Now the question is, my lord, on this point, see, my humble submission is, my lord, the learned single judge's basic understanding was that this prescription of 3.9.0 is mandatory, therefore this election is banned. That, in my humble submission, is not correct because, my lord, it is neither the case of the college authority, it was neither the case of the respondent number 10 appellant. Our case is, my lord, my experience as a research scholar need not be counted for giving me these marks. My marks should be counted because I'm teaching in Disney College.
Over and above the research fellowship.
My lord. So where is the scope? Now, my lord, coming to the 2 judgment of this honor, before that, my lord, Kalyani Mathivanan's case, 2015 6, Kalyani Mathivanan. 2015 6 SCC 360.
No experience that will not be counted as teaching. But she has violated the and she is not whether that teaching. So she's eligible. Maybe UGC can put a question mark in a research. Maybe recovery can be.
Over and above what we say.
That is what I'm saying. That is something contrary, maybe contrary to the UGC conditions. That is taken as a consequence of your point.
These are Assam government acts.
Yes. Please come to para 62.4, my lord. The conclusions.
Yes.
UGC regulation 2010 are directory for universities and colleges and higher education institution under the purview of state legislation. as the matter has been left to the state government to adopt and implement the scheme. Thus, the UGC regulation are partly mandatory and is partly directed. So, my lord, after the judgment, there is no dispute that unless the state adopts it, my lord, it is not mandatory, it is directed. Now, my lord, based on this, my lord, the state has taken stand in two cases. I'm drawing your lordship's attention to it. Yes,
There is a letter.
yes, my lord.
We'd like to bring, like you to refer to that letter. Come
Yes.
to page 203.
Yes, my lord. That 18 later,
Yes,
but that is of 2018, my lord.
yes.
It even says that it is permissible. F,
Yes.
period of time taken by candidate to pursue MPhil and PhD degree will not be counted as teaching experience as state government is yet to adopt the UGC. Yes. My experience as the JRF was never taken note of by anybody.
We understand.
The-
Yes,
The case proceeded on a basis as if, my lord, because I am doing JRF, therefore the 8 mark was given to me
Yes.
beyond 3 years. So it is not that, it was given to me because,
because you taught independent of JRF.
yes.
Yes,
My lord, that may entail, supposing I flout the condition of JRF, my lord, my.
UGC may take steps against you.
Yes,
Consequences
yes,
would follow by
yes,
UGC.
yes, my lord, regarding the two judgments, my lord.
Yes,
এখন দিয়া না? এই, 2022 5 GLT 87.
yes.
Oh. My junior has given the book list.
What is this? Archana
My lord,
Sharma?
this is again on the point of adoption by the state, my lord.
Yes,
I'm just reading it, paragraph 5, my lord. Mr. D. Saikia, learned Advocate General Assam, on the other hand, submits that as per serial number 1 of the terms and conditions of advertisement for the post in question, it is clearly provided that eligibility of the applicant will be strictly ascertained on the basis of UGC Regulation 2018, but same is not the case in respect of the selection process. He submits that eligibility and selection process are two different things. And in fact, state of Assam has not adopted UGC Regulation 2010 or 18.
even the statement was made by Mr. Saikia about a couple of days back.
Yes.
Yes,
So, my lord, the status stand of the state government is UGC circular was never adopted.
Mm.
Now, my lord, single judge proceedings on that basis only. Because the finding which I have referred to, it clear the learned single judge has recorded a conclusion that this is mandatory because it was therefore in violation of that mark was given to me. It's a different matter that mark was not given to me on account of that. So therefore, my lord, the interference with my selection was bad, my lord.
your client was selected.
Yes, my
She
lord.
continues on the post.
No, because my lord, the approval was state. There's a requirement of approval by the BTC. There was at that stage, they, my lord, approved the court.
Okay. There's a status quo on the SB order.
Yes.
Okay.
Interim order, আছে তো না?
Yes, there's a status quo.
So by virtue of that, my lord, I was not formally appointed pursuant to my selection. এটার position, no?
The post remains vacant.
Vacant.
Okay. Very well.
So this is my case, my lord, subject to what my learned friend says, my lord.
Yes, Mr. Nayak.
My lord. My lord, if a cursory glance is taken of the matter,
Yes,
then my lord, a view can be always formed that this being that person having already taught in that school during that period, my lord, that experience must be gathered to. But my lord, the UGC regulations go beyond that. And lordship, at the very outgo, I would say, there is a latest judgment of the Supreme Court, wherein, my lord, all these things, wherein it was said that UGC is directory or whether it is mandatory, that have been done away with. And now the Supreme Court says the UGC regulations are mandatory and has to be followed. 1. 2, it all boils down to that 3.9. 3.9 says, lordship, 3.9 says that the period you have spent for PhD, JRF is nothing but PhD. Madam. That period will not be counted for teaching and
that
research.
period by itself,
Will not be counted.
That's what we are saying,
Lordship,
that period by itself.
Lordship,
But she is not claiming that her time spent
Lordship,
as a research fellow
Lordship.
should be considered to be teaching experience.
Because my lord, she was at that point of time teaching in the school also.
Yes,
She was in the university, my lord.
yes,
I'll satisfy you. Also. She was in the university and she was sitting in a school.
yes.
Now, my lord, the government of Assam in 2012 had adopted 3.9. my lord.
Hmm. Assuming
No.
3.9 is still applicable.
Lordship,
Yes,
Lordship, Lordship. Now, my lord would come to the provisions of 63. I'll place that 2012, page 63. my lord.
yes. Yes, please.
My lord, we'll have the opening words, my lord.
Hmm.
Guideline for selection of assistant professor, distribution of marks for ranking of candidates. In conformity with UGC guidelines
Hmm.
and in partial modification of earlier OMs in this regard for selection of so and so, distribution of marks is prescribed as follows.
Yes.
So my lord, teaching experience, my lord would find in the middle, teaching experience, 10 marks.
Hmm.
Now my lord would come to page 64.
Yes.
My senior has taken my lord through that. Para
Yes.
3. Teaching experience shall carry 2 marks for 1 year of experience of teaching undergraduates in the state government recognized colleges, subject to a maximum of 10 marks. Now, this is important, my lord. This will be related to actual hours of teaching imparted by candidate in a particular year with the standard teaching hours of a regular assistant professor as per UGC guideline. Now, UGC guideline says, my lord, the teachers, the workload of a teachers in full employment should not be less than 40 hours a week or 30 working weeks. And it will be necessary for the teacher to be available for at least 5 hours daily in the university college for necessary space should be provided.
Yes.
So, my lord, a teacher to fulfill that condition must be in the college for 5 hours every day. Now, my lord would come to page 104, my lord.
Yes. Yes.
The last
Hmm.
paragraph there.
Yes.
Also certified that the fellow should not accept, hold any emoluments,
Hmm.
paid or otherwise, or
Yes.
receive emoluments, salary stipend from any other source during the tenure of the award.
Yes. What would be the consequence
Lordship,
of violating this
my
condition?
lord, I'll bring not on the consequence. I'm saying that she does not fulfill that condition.
Oh, sir, we are putting you a question.
But the
What would be the question? What would be the consequence if the candidate violates this condition?
this condition, my lord, it would be of that teaching experience would be of no use.
Wait a minute, sir. Wait a
My lord,
minute.
let
Wait a minute.
Lordship.
Just wait a minute. The consequence to our mind would be that her fellowship may be cancelled.
Lordship. That's
But
one way.
how would that eschew
My lord,
on her teaching experience?
my lord, I'm not on that. I am
Yes.
saying, but I will not say, my lord, that she had not taught. But whether that teaching would satisfy the requirement for 2 marks. My lord would come to, it starts at page 108.
Yes.
That is the guidelines for the JRF.
Hmm.
I'll only have my lord's attention at page 112.
Yes.
After this, my lord, I'll submit that she does not have that qualification.
Hmm.
The fellow with the consent of the guide head of the department may assist the university institution in its academic work, including tutorials, evaluation of test papers, laboratory demonstration, supervision of fieldwork, library activities like group seminars, so and so, provided such work is not likely to hinder the program on hand. The total amount of time to be spent on such activities should not exceed 10 hours a week.
Hmm.
So, my lord, the UGC regulation says that if you want to have that mark, you must serve in the college for 5 years. Whereas there is a bar in the JRF itself that more than 5 hours, 10 hours in a week, you cannot teach. So, my lord, in this view of the matter, that experience is no experience in the IF.
Yes. Yes.
I would like now, my lord, would come to the judgment, my lord.
Yes,
My senior has taken, my lord. I'll not trouble your lordship with a thing. I'll only have my lord's attention at page 220.
yes,
My lord, the second paragraph from bottom, it's the director's letter. In my copy, my lord, it's not legible, so I'm reading it from here. My lord.
Mhm.
My lord has already read it. Second paragraph from bottom, my lord, page 220. Further also, page 220,
Mhm.
further also, read and peruse the resolution number 2 of the governing body meeting held on so and so and report of the principal. It is stated that Mrs. Asharani Brahma has been regularly attending the college during JRF period. Well, this is what I was trying to point out. The selection committee don't know about her doing JRF PhD.
that was concealed.
That was concealed. So
Yes.
if that was disclosed, my lord, this would not have come into operation. Now, my lord, how the honorable single judge has done it. The stand of the UGC at page 222.
Yes,
Para 5.
yes,
Mr. So-and-so learned counsel appearing for UGC submitted that UGC regulation.
that is
memorandum-
quite okay, we understand.
Lordship. And then-
3.90 only means
Lordship.
that the experience as a research fellow will not be counted towards teaching. Her case is not that. Her case is, in addition to JRF, she was also pursuing teaching.
My lord.
No, for that you already made the argument
Hmm.
that she could not have taught for 40 years a week.
Lordship.
That you already stated. Yes,
And if that cannot be done,
yes,
then my lord, in terms of that page 64, 63, 64 OM,
yes.
2 marks cannot be given to her.
Understood.
So accordingly, my lord, that is not maintainable. Now, my lord, that latest judgment of the Supreme Court, 2022 5 SS. I have copies.
Yes, yes,
Lordship would come to para 27. This was in context of that vice chancellor's thing, but the Supreme Court has, my lord, dealt with the UGC regulations. Para 27. Prior to enactment of the UGC regulation 2010, the Union Ministry of Human Resource Development laid down a scheme of revision of pay of teachers and equivalent cadres in the universities following the census. The scheme provided fixed pay of rupees so and so along with special allowances for so and so. It extended to universities, college and other higher coming under the purview of the state legislature, provided the state government wished to adopt and implement the scheme with certain conditions, inter alia, a financial assistance from central government to the extent of 80% of the maintenance expenditure. And 20. It further provided that payment of central assistance for implementation of scheme is subject to condition that the entire scheme of revision of pay scale together with the conditions to be laid down by the UGC by way of regulation, other guidelines to be made. In the present case, the said state of Gujarat had adopted the scheme on so and so by a resolution so and so with effect from so and so, subject to the condition mentioned in the said resolution. Even in the said resolution number 13 provides the state government will publish educational qualifications as per UGC instructions published from time to time and quality yardstick teaching of working days, norms, instructions, resolution will have to be implemented. It is not in dispute that the SP University is receiving central financial assistance under the scheme, and it is included in the state university receiving central financial assistance as per section 12B of the Act. However, therefore, having adopted the UGC scheme and implemented the same after getting central financial assistance to the extent of 80% of the maintenance expenditure, the state government and the SP University are bound by the UGC regulations of 2010. The UGC regulation 2010 are superseded by the UGC regulation 2018. However, the eligibility criteria for the post of vice chancellor and constitution of such committee for so and so, therefore, the state of Gujarat and the universities thereunder, including the SP University, are bound to follow UGC regulation 2010 and 2018. Now, my lord, proceeding further, the Honorable Supreme Court said, para 50.
Ji.
it cannot be disputed that the UGC regulation are enacted by the UGC in exercise of powers under section 26(1)(e) and 26(1)(g) of the Act. Even as per UGC Act, every rule and regulation made under the said act shall be laid before each house of the parliament. Therefore, being a subordinate legislation, UGC regulation becomes part of the act. In case of any conflict between the state legislation and the central legislation shall prevail by applying the rule of principle of repugnancy as enunciated in Article 254 of the Constitution of India as subject. Education is in the concurrent list of the 7th schedule to the Constitution. Therefore, any appointment as Vice Chancellor contrary to the provisions of the UGC regulation can be said to be violation of statutory provision warranting a writ of quo warranto. Then, my lord, it said, after that, my lord, it goes ahead and says that the appointments that have been made are bad. And my lord, it should be in conformity with the UGC regulation. So that doubt, my lord, whether it's directly or mandatory has been laid to rest. Now, my lord, this page 63 and my lord, that 2012 notification, that circular is before your lordship
Yes.
in form of an, no, I'm sorry, my lord, the paginations are not being made here. My lord, it was an additional affidavit filed by us on 5/3/2020. my lord. I can give a copy, my lord.
Please do. It's 25th June.
No, my lord, it's March.
No, the.
25th June, my lord, 25th June.
We have it.
My lord will have this
242.
242, my lord.
Yes. The
Guidelines
affidavit
for
is,
selection of lecturer, assistant professor, librarian in provincialized college, as per UDC guidelines, excluding the criteria of awarding oral marks. Then, my lord, selection procedure for the professor, post assistant professor, my lord would come to page 243. The period time taken by candidates to acquire MPhil or PhD degree shall not be
that is
considered
3.9.0. Same clause.
has been adopted.
Yes.
Now, my lord, this was further clarified in that page 63 office memorandum, my lord, wherein it says, now to be eligible for that 2 marks, you must teach in terms of the UGC regulation,
guidelines.
which, my lord, the petitioner has not. So in this view of the matter, my lord, the difference, appellant, sorry. my lord. Now, my lord,
Yes.
the paragraph 228, my lord,
Yes.
my lord has already got it. That was the conclusion of the honorable single judge.
Yes.
Even if my lord holds that period, JRF, she is pursuing that period, she will not, but that experience would come in. That experience has to be, my lord, in terms of
UGC.
UGC regulation
UGC.
in at page 63 and 64,
Yes.
which is not. So, my lord, she had a service of 2010 to 2016. She'll be eligible for 2010 to 2013, 2 months, 6 months, which has been given.
Yes.
So 2 into,
3.
no, my lord, 2
6.
into 9. There were 9 members, 2 marks each they give.
Mm,
So that has to be deducted. So 18 marks goes.
Yes.
Our difference was around 1 point something. man.
Mhm.
So I become number 1, and that recommendation, my lord, at page 229, the honorable single judge had interfered in para 11, my lord.
Yes.
Therefore, the recommendation is quashed, set aside, and my lord, they were directed to consider the matter afresh in terms of the incident. So, my lord, this is my humble submission. In any view of the matter, for that period, my lord, she is not entitled to.
My lord, just 2 minutes reply, my lord. My lord, regarding the judgment which my learned friend has placed now, whether that will apply retrospectively or prospectively.
Irrespective. Even the Assam regulations, OM
Yes,
of June 2012, it's very clear.
yes.
3.9.0 has been adopted by the state.
No, my lord.
Are you having a copy?
Yes, I'm having it, my lord.
Yes.
Lordship is correct. No,
Yes.
I'm not on that, my lord. What I'm
Yes.
trying to say is, first I'm trying to say that Supreme Court judgment, whether that will apply prospectively or retrospectively, that is an issue to be gone into.
Yes.
Because the selection was of 2016 and the whatever law, whatever of, OM was, prevailing on that day, that will govern this election.
Yes.
Number 2, my lord, it is nobody's case other than the writ petitioner that 3.9.0 was invoked to give me those marks. It is not our case. Our case is, my lord, we were given the marks because we are otherwise were eligible because we are working in that business college in contractual capacity. In fact, my lord, this, I'll just do one more thing, my lord. We filed an additional affidavit, my lord, on 1st of February. I'm sorry, my lord, this pagination has not been, made, my lord.
22 to 21.
My lord, 1 second. Yeah. My lord, 21 to 21.
22 to 21. it is.
Yes, if your lordship would kindly come to page number 4 of that affidavit.
47.
Page number 3.
Yes.
This is to certify that Asarani Brahma was a junior research fellow under the Borderland University for the period from so-and-so to so-and-so white PhD registration. As a JRF, she is entitled to get fellowship from UGC. She received a sum of rupees so-and-so for the year 2013-14, and thereafter she did not apply for fellowship, and she was not paid any fellowship for the rest of the 4 years.
This is
From
issued,
14 to 18, she
This
has
is-
already completed her PhD.
this is issued in 2021, sir.
Yes, 20, because there was a, no, my lord, this honorable court directed that whether you to avail also the benefit of, my lord, because this matter was heard on several occasions, my lord. That's why, my lord, yes, it was given on 19 to 21. So the fact of the matter is, for the year 2014 to 2018, I have not claimed, my lord, anything. In fact, my lord, they filed an affidavit in opposition to this, to which we have filed and reply, wherein we have annexed document to show.
That 1 year for which you took the fellowship,
Yes.
that is a crucial year.
No, my lord, I'm not on that. No, lordship will take.
That is the very year for which
No,
you have
correct.
claimed 2 marks.
Correct. No, my lord, my case is, I was entitled to 10 marks. Of course, I haven't filed any writ petition to say
So
that.
that's
Yes.
not a
So-
permissible
So the
argument.
question is, my lord, the marks which was given to me for serving in, my lord, at this business college, whether that can be construed to be an act which is not permitted by UGC regulation.
Very well.
Because the UGC regulation speaks of JRF. It is there wrong and my lord, how does your lordship deal with this para of the learned single judge, my lord? At page 228, para 10. Kindly
Yes.
see, my lord, as stated by the Honorable Supreme Court in the case cited by Learned Counsel for UGC, UGC Act is mandatory for all universities and colleges, are both open and formal. That was not the correct position of law on that
Yes.
day, my lord. On the contrary, the position of law was when it comes to state universities, it is directory.
Yes.
So learned single judge's basic reasoning is 3.9.0 does not enable the selection committee to give me mark because admittedly I was a JRF at the relevant point of time. And secondly, my lord, this is mandatory. So lordship will have to deal with this aspect of the matter in my
Yes.
submission, my lord.
My lord, this was placed before also, but I'm not sure whether it's on the record. There was an RTI reply, 2013-14 she received, 14-15 also she received. And her application for that is also there, my lord. If my lord can just, it will- just turn over to the, my lord, 2 pages more. She applied for that. 14-15, 13-14, 14-15, we have records.
Chaudhary, if this is so,
Yes, my lord.
you are guilty, your client would be guilty of filing a false affidavit.
My lord.
The client would be responsible for filing a
No,
false.
that's a certificate issued by Borderland University.
Maybe you have filed it on affidavit.
No, I have filed it, but that's a document of the university.
Just have a look at it, please.
So I've given.
These are banking details. So even the affidavit may be false. The certificate may be false. It's quite possible.
Could do.
13-14 paisa, 14-15.
Could do.
14-15.
Ah.
Apni ago 13-14 is it?
No, my lord, I have not claimed from 14 onward. That's what the certificate says. It is not a false statement, my lord.
RTI.
No, my lord,
RTI.
RTI says I was paid only for, even this is important.
Then वापस देना.
No, my
Give it
lord,
back, please.
no, the affidavit which we have filed wherein we have annexed a document of the Borland University that says, my lord, kindly see, my lord, I have not
Yes.
claimed, money may have come. Yes. No, no, you can't put there, I'm sorry.
Sir, thereafter she did not apply for the fellowship and she was not paid any fellowship for the rest 4 years.
Yes. Yes.
She has been paid.
14.
One second, Manu, we'll have to clarify this.
Yes.
I think it 14-15 will be good question.
Report us, report us. Wait, wait, wait.
We may be persuaded to,
No, no, my lord, what?
And
lordship,
direct
there
some
may be
action.
some misunderstanding. It's my duty to clarify that.
yes, please.
This certificate says that I was paid for the year 13-14. Yeah.
And no further amount was received. That is what the certificate
No,
is.
well, I have never
Please.
claimed.
Please receive. Please read. She was not paid any fellowship for the rest 4 years.
Yes. One second.
Yes.
This is to certified Asarani Brahma was a junior research fellow for this so and so, so and so, so and so. She was entitled to get fellowship from UGC. She received a sum of rupees 2,24,000 for the year 13-14, and thereafter she did not apply for fellowship and she was not paid any fellowship for the rest 4 years. This is this.
She was not paid.
Yes.
And this certificate says she was paid for the year 2014.
Last one.
Can you go, sir? In persons of the approval by the Honorable Vice Chancellor, recorded the sum 11,000. The expenditure 14-15 will be published.
Okay, bottom, bottom.
In persons of the approval Vice Chancellor dated 9/4/15, sanction is hereby accorded on the sum of rupees 1 only 11,24,000 to the following Asarani Brahma. But it is for 14 billion code class.
You may clarify it was sanctioned,
Yes.
whether your client accepted it or not.
My lord, we'll
My
have
lord,
to-
application is there, my lord. Application is there. My lord, after the first,
No, no, my lord, there is some confusion. my
1
lord.
to 3rd page, my lord.
Hmm.
Annexure 2,
Ah,
application is there.
yes. Now there is, this is something serious. Chapter closed.
Kunkindi,
Right.
portion?
Wait, wait, wait.
No, no, no,
Now,
application.
applied for and received
We-
both.
Yes, I have the honor to request, the honor to release,
22,
which is a
1,
sanction against my name by UGC by later dated it now.
22, 1.
Now it will be
Ah.
probably safer to seek proper instructions.
Yes, my lord, definitely, my lord. Now, if it is a false statement, it's a very serious matter. Even I will,
Yes, on the face of record.
no, my lord, there is some confusion because there is a certificate given by them that I have not claimed.
This is false on the face of it.
No, my lord, I'll have the instruction on this, my lord. Whether for the year 14-15 I received anything. Because eventually, if I receive it, then only it will matter.
You have claimed, that is sure.
No, claim is, no, my lord.
Ms. Chaudhary, you are filing this certificate
Ah.
on affidavit.
Ah.
Certificate says not claimed,
Ah.
whereas the fact remains your client has claimed. Receiving is immaterial.
Anyway, my lord, I'll have the instruction, my lord.
We are passing it over for the timing.
My lord,
Call your
today,
client,
today, sir.
convey it on WhatsApp and ask her.
It will know, sir.
Yes,
Lordship may call it at 2 o'clock, my lord.
yes.
Much okay.
That's a job well done.
Item number 13.
It's like, who care for it?
Talaq.
May I please?
Yes.
My lord, the matter relates to my lord.
Yes.
But I'm appearing for the appellant. But from my, so far as I am concerned, I am the ex-husband. They may say that present husband, but a man. But just before going into the merit, my lord, some factual aspects are there, some dates are there. But these are all very much relevant for the case. But the marriage took place on 5/12/99. It was in the year 1999. Then, my lord, as per the averment of the lady, my lord, they separated on 28/4/2009. So, my lord, after 10 years, my lord, they separated. Then
Yes.
thereafter, my lord, the man issued a talaq notice in writing. First, it is a first talaq, my lord, because triple talaq is not valid. It is not a triple talaq. Talaqul Hasan, which says, my lord, that one talaq would be given today. Then after 1 month, second talaq. Then after 1 month, then third talaq. On the expiry, on the pronouncement of third talaq, it becomes final.
Mm.
Otherwise, it can be revoked at any time and by words or conduct. Now, my lord, the first talaq was issued on 27/5/2009. Lord, and it was also, my lord, submitted before the official who has to register it. Now the act says, my lord, it has to be registered, but act also says if it is not registered, it's not making it invalid. So registration is not material for the purpose of, my lord, validity of the talaq or even validity of the marriage. So, my lord, after this, the registrar issues a notice of this first registration. On he registers, gives the number. Then thereafter, my lord, he issues a notice on 5/6/2009. For which, my lord, the lady, then wife, my lord, she gives an objection on 12/6. Against which, my lord, she preferred an appeal on 12/6 also. On the same day, she preferred an appeal to the superior authority as provided, my lord, in the act. My lord, these are all the dates, my lord, so far as the first talaq is concerned. Second talaq is concerned, my lord, the second talaq was pronounced exactly within on expiry of 1 month on 28/6/2009. Then, my lord, notice was issued by the registrar on the next day, 29/6/2009. She did not object it. She did not, my lord, approach the registrar, or she did not prefer any appeal. So appeal was confined only in respect of the first talaq. Then, my lord, third talaq was issued on 2/8/2009. And, my lord, even in this respect of, my lord, this third talaq also, my lord, no appeal, nothing. So on the pronouncement of third talaq on 2/8/2009, my lord, talaq has become final and irrevocable. Now what happened was, my lord, the appeal which was preferred for the first talaq, my lord, in 2009, June, it was dismissed in 2010 November. After the expiry of, my lord, about 14 months or 15 months. Then thereafter, this lady comes to the court, challenging, my lord, only the two talaq notice issued by this registrar who registered it. Now, your lordship, maybe, and in which, my lord, the status quo was given. Status quo means, my lord, at that point of time, my lord, the talaq was already over. It become irrevocable. So, my lord, it is not having, my lord, any kind of, my lord, practical utility.
Hmm.
And now, your lordship, please see, my lord, so far as factual aspects are concerned, my lord, regarding the status of the parties about marriage, separation, these dates, my lord, there is no dispute. Now, your lordship, please see, my lord, the prayer in the writ petition. What she wanted, she came to the court. Now the thing is, my lord, your lordship, please see, there are two things. One is, my lord, the factum of talaq and validity of talaq. That is the first aspect.
Second aspect is regarding registration of this factum. This is the second aspect. But so far as the factum of talaq or validity of the talaq is concerned, so far no challenge. If there is a challenge, she has to go to the family court, not to the writ court. Because family court, as per the Family Courts Act, it is having jurisdiction to decide about the validity of talaq or even this status of the parties in between. She has not challenged it. And section 24 says, I am reading Milord, so far as section 24 is concerned. There is an act, Milord, the local act. Sir, book. We are having a book also. Give it. No, I have underlined. Just give it.
Yes.
We are having only one book, Milord, then there is a.
It's okay. Yes.
I have underlined. Your Lordship, please see page 10 of the book. Page 10 of the book, Milord, section 24. Saving class.
Yes.
May I read this, Milord?
Yes.
Nothing in this act shall be construed to render invalid merely by reason of its not having been registered any Muslim marriage or divorce which would otherwise be valid. So, my lord, suppose I am not registering it, or even suppose registration is challenged properly and that is set aside.
Yes. Carry on.
But registration is challenged and that is set aside. It is not making any difference about the status of the parties. Now, Your Lordship, please see page 30 of the paper book.
Yes.
What she prayed.
30.
No, now, so far as I'm concerned, I'm not here. I'm not from the local bar. I'm in Delhi.
No, it doesn't make a difference.
Regularly, some of the judges they used to say, merely because this state is near to Delhi, you are preferring each and everything to the Supreme Court like that. Similarly, same analogy applies here also. A person, maybe he may be having some kind of connection with the legal practice. It doesn't mean that immediately the jurisdiction of the properly constituted court can be given a bypass.
Yes.
And writ jurisdiction can be invoked. Only for that analogy I am saying, now we lost page 30, para 28.
Thanks for enlightening us.
Yes. Page 30, para 28.
Yes.
The petitioner is this lady Miller. The petitioner submits that the impugned action of the respondent number 3 in register. Respondent number 3 is the person who registers. He's not the appellate authority. He registers it. Respondent number 3 in registering and issuing the assent talaq being absolutely illegal, arbitrary, unreasonable, and in violation of the statutory rules in force, the same is liable to be interfered by the Honorable Court in the exercise of under 220 without jurisdiction, same is void. Then, my lord, now prayer. Prayer is, my lord, in the same page, para 32. That this petition has been filed bona fide and for the interest of justice. In the premises aforesaid, your petitioner prays that your lordship may be pleased to call for the records and issue rule calling upon the respondents to show cause as to why a writ in the nature of certiorari, they have sought for certiorari. This is also another point that may not be relevant because other things are very much strong. Writ of certiorari should not be issued and the impugned registration of so and so. So what is challenged is only the registration of so and dated 27/5/2009, talaq 2 dated and the order dated 29. So, my lord, what is challenged is the registration of first talaq.
Where is the order dated 29/6?
29/6, it is, my lord,
Page number.
But 29/6. Is the, no, page 44, madam.
Reply to objection.
Page 44, madam. That is
Yes, yes, we have,
49(6).
yes. Yes,
Yes. So date is also not correct. But we can, your lordship may ignore this, this mistake. But this notice, what was challenged is, my lord, the first talaq. It's registered, not first talaq, the registration of the first talaq, that's all. So, my lord, the validity of the talaq that was pronounced at 3 stages, that was not at all challenged.
what happened
So-
to the third talaq?
It was given, my lord, on.
Where
on-
is it?
On 2/8. But she only filed, my lord, that is not filed. That is not filed here, but we pronounce it, that is over, because within a month it has to be given, and just 1 month gap is to be there. On 2/8, my lord, is the third talaq. Also, please see page 10. We have specifically stated, page 10. In the middle, the opposite party number 3 issued 3 notice on 27/5/2009, 28/6/2009, and finally on 2/8/2009.
Yes,
So these 3 talaks are over. The talaks are not challenged.
but
And
you said so, sir, 4 times.
Yes.
Need not repeat.
these notices, my lord, in respect of, my lord, the first talak, notice was issued by the registrar, and that notice has been challenged, only that notice. So far as the second is concerned, notice was not challenged, the third is concerned, they have left it is. Now, your lordship, please see, my lord, the once, my lord, this is placed before the court, what the court can adjudicate is whether this registration is valid or not. Only that thing can be done, and it cannot go beyond.
Yes,
Now, your lordship, please see, my lord, what has been decided. It is not that, my lord, whether this registration is correct or not, it was decided. The court has decided whether the talaq is valid or not. Your lordship, please see, my lord,
yes.
page 69. Page 69. Last but one paragraph. Just only 2 lines. Consequently, Hasan Talaq 1 dated 27/5/2009 and Hasan Talaq 2 dated 28/6/2009 are set aside in quash. Talaq is set aside. It was not at all challenged.
Yes,
So, my lord, this is so far as the judicial proceedings are concerned, my lord, it is subject to principles of natural justice. If anything is placed before the court, it should be supported by pleadings,
Beginning line. These are the.
yes.
and it should be.
No, which is fact, actually correct. It's not repeating. Not repeating. It is not prayer. Prayer is against restriction. Yes,
It should be supported by the pleadings. I should be given an opportunity. Then I should, I would file my counter, or even in this case, I did not file a counter because because what was challenged is only the registration. All right, suppose if they want to challenge it, only the one registration was challenged. All right, suppose if she wants to get an order letter, like that, I left it. Suppose if this had been challenged, I would have filed my counter, I would have contested, including the question of jurisdiction. 226 should not be invoked. And all these facts also has to go before the family court. All these things I would have raised. Without any pleading, without giving an opportunity, this has been, talaq has been set aside. So this is the main ground.
yes,
First aspect. Second aspect is,
yes.
regarding whether only this first notice, what is the nature of function of the registrar? A person who is coming to the sub-registrar office, he is not doing any judicial or quasi-judicial work. It is just receiving fee and making an entry in the, if all the annexures are there, he would make an entry and he would issue a certificate. This is only an administrative function. So, when a person is doing an administrative function, this cannot be a subject matter for certiorari. Second thing. The third thing is, when an administrative power has been used, And so far as state jurisdiction is concerned, my lord, it should be an,
Yes.
my lord, if there is no other effective alternative remedy, he can do that. Here, my lord, when without challenging the talaq, only the registration and the challenging the
You
only
have said, sir, you have repeated
first
five
registration,
times.
this is also not correct, my lord. So, my lord, this is the crucial point, my lord, on which, my lord, I am challenging the order issued with a single.
Yes, very well. Yes,
May I, Your Lordship? But in this case, Your Lordship, my friend has already shown the player. My lord, what happened in this case, my lord, when 27.5, this first talaq was given, my lord will kindly come to.
what have you challenged, sir? Read your prayers, please.
Yes, my lord, I have read the prayer, my lord.
Sir,
I have read.
So where is the talaq challenged?
Huh?
Where is the challenge to the talaq?
No, the talaq is on the same date, my lord. Your Lordship, that's what I am trying to point out to my lord, my lord.
It could not have been completed
My lord,
without the third talaq.
my lord, your Lordship, kindly just give me just a minute. my lord. So far, third talaq is
Really,
concerned.
full, don't worry,
No,
got the whole day.
The third talaq is concerned, my lord, we have not received any notice, nothing has been done, my lord. And that fact has not been mentioned. They have not filed any affidavit before the trial court, before the, my lord, single bench, when the matter was pending for last 7 years, my lord, were pending there. This
How does
fact-
the question here is, why does the writ court usurp the jurisdiction of a family court? If you are aggrieved by any step of talaq, is there a family court to deal with it?
My lord, my submission is that, my lord, if it is, would have been a question of only talaq, not registration and anything. But definitely, my lord, my lord, the
So
court.
if
would not
the question
interfere.
is of registration,
My lord, true, my lord.
then registration, setting aside of a registration, is it again the domain of a writ court? Why not a civil suit?
But it can be done in civil court also, my lord. It is
Then
not that, not
if-
that, my lord, the
if-
civil court.
if
civil court
a remedy-
jurisdiction is barred.
If a remedy is available in a civil
Civil
court,
court jurisdiction is
would-
not barred, my lord. I'm not. I'm
sir,
not
we are,
making-
we are asking you, why a writ court should step into the shoes of a civil court?
My lord, your lordship will kindly see, I have given the facts, your lordship will see, even appellate authority has said that this registrar has no jurisdiction to entertain the registration itself, my lord, because he does not have, it is in the Barpeta district. Party belongs to Guwahati, my lord. My lord will kindly come to my lord page.
Yes.
That aspect has also been dealt with by general
Yes.
single judge, my lord.
Yes.
Page 57.
Just a minute, Mr. Agarwal. Mr. Agarwal,
Okay.
leaving aside the technical issues, which if necessary, we will deal with it. But is there any possibility of any amicable settlement in the matter? After so many years?
That can be, my lord, because he has married for second marriage, he has already, my lord, after this, my lord, given the talaq, sometime in 2011, he has got married again.
Mm.
So, my lord, the matter can be, my lord, sent to, my lord, mediation or whatever is possible, my lord, this can be
No,
done.
no, the appellant wants a talak.
Yes, ma'am.
What is the stand of your client?
They are living separately since long 7 years. Without possibility of living together may not, my lord. The question of, my lord, compensation and other things will arise. Basically, my lord. My lord, if I have to, my lord, be fair, very fair to, my lord, both sides, my lord. My lord, she is living since 2010, I think 2009 she was, my lord, ousted from the, my lord, matrimonial home.
Yes.
And
And
it is now, my
Mr.
lord, 13 or 13 years, my lord.
Mr.
More than
Srivastava,
13 years.
We are also asking you, even if you succeed in this case.
Yes.
The matter can merely go back to the family court. That's all.
Yes, my lord. No, let
So-
them up.
So what is the point in getting entangled in these matters at this stage? If both sides agree, we can explore the possibilities of an amicable settlement and finish it.
No, we would do that. Lordship, please to dispose of this appeal. But we assure you that, assure this honorable court.
No, we are not disposing it off. Make an attempt to at least bear some kind of compensation.
Under the, by keeping this proceeding, this may not.
Very well, then we'll simply observe. There is no third talaq. So there is no valid talaq in the eyes of law. We'll observe. Don't worry.
Madam, that is.
So then, why do you take on stand on these just technicalities? Make an attempt. The court has observed.
He's in Delhi. We have to, he's in Delhi, he's in sitting, sitting empty now. He's
Yes,
really-
so let him make an effort.
We have to get an instruction, my lord, in that regard, my lord.
Yes,
We can take instruction, my lord, if any possibility is there, then we can.
complete your instructions
So far,
on
my
this.
client is concerned, my lord, she is ready, my lord. See, I have got the instruction in the morning itself, my lord, that
course.
she is ready to, my lord. Because, my lord,
Good.
ultimately, it will not serve any purpose, whether, my lord, your
Yes.
lordship will set aside the matter. Or your lordship will allow this matter, my lord.
So all right, you complete your instructions, Mr. Boyan.
My lord.
When?
Lord, at 2 PM, my lord, we can take telephonic.
Very well, at 2, come back at.
Yes.
Okay. 2 o'clock.
Yes, much.
Item numbers 15 and 16.
No one there. Yes.
Please, your lordship.
Yes,
May please, your lordship. One of the appellant herein, they were appointed in the year 1998, my lord. Thereafter, in the year 2012, they were terminated, my lord. That was put to challenge, and the honorable court said that the termination was bad. So it was directed for a de novo proceeding.
Mhm.
And thereafter, the inspector of schools, Nalbari, my lord, they conducted a proceeding, and he said the termination was bad. They were reinstated into the service along with their current salaries.
Mm.
And thereafter, they approached this honorable court, my lord, for the area pay. That is from the period where they were in suspension, my lord.
Mm.
And that was not allowed by this court, so this appeal, I filed this appeal.
Where is the state? Education?
My lord, in fact, some similarly situated persons have approached this honorable court, and this court has allowed the prior, my lord. May I please this.
Let us see. Hmm. Same order, same order. Yes. Education Department. Same order. Same. Hospital. Yes. Already on the record.
Item number 5.
Yes.
May have the loss. Well, the other day, that is on 3/3/23, your lordship directed us to take dusty service upon the private respondent.
Yes.
So accordingly, we have taken steps. Some persons have accepted the notice, some have refused. So in this regard, we have filed an affidavit.
So let the registry report. Let the registry make a report.
Registry means we have filed affidavit that is on record.
चलो 2 दिन कर दीजिए करना
That is on record.
2 days delay of 2 days.
Yeah, only 2 days, well.
कर दीजिए
Actually, if the BU holidays counted, there is no delay. Even then, we have filed as per desire of the.
Mr. Godole, you are appearing,
Lordship, I appear for the co-person department.
2 days delay.
नोन कर दीजिए सर्विस प्रिज्यूम कर लीजिए प्रिज्यूम सर्विस
After perusal of the office note, we presume service of notice upon numbers 1. This IA has been filed with a prayer to condone the delay of 2 days in referring the connected appeal against the judgment and order dated 9/1/2023 passed by the Learned Singaja in WPC 76/2023. So and so. Peruse the statements made in the IA having regard to the explanation furnished in the applicant, we are of the view that the applicant was prevented by sufficient cause from filing the connected appeal within the prescribed period of limitation. The delay of 2 days is therefore condoned. IS stands disposal, before the registry to release the appeal by admission, IS stands.
My lord, I have another prayer. 31st March is the last day for us. So the writ appeal may kindly be listed
Monday.
before any day.
Monday.
Monday. Hello, bless.
Item number 17.
चला दीजिए थोड़ा बंद कर yes
For the respondent railways, my lord, the petition appellant here
here's in person
is in person, my lord. He has challenged an order passed by the single judge, my lord, dismissing his writ petition. In the writ petition, the case was, my lord, that the action of the respondent railways in discharging the tender process, my lord, was actuated by malice, my lord. And that is not the case, my lord. The lordship peruses the
Is there anything live in this case?
nothing, my lord. And even at this stage, my lord, there are no funds to, my lord. Funds are also not available for, even if your lordship holds that, my lord, he is entitled to carry out the work, the funds are not available to the railways, my lord, for that particular work.
Sufficient.
None appears to the appellant when the matter is called up. Mr. B. Sharma, Learned Standing Counsel and Railway submits that the appeal has become infectious. You are appearing?
He is also for the railways, my lord. Both of us
So
are.
and so for the railway submits that the writ appeal has become infected. Please attach since the appellant is absent, this matter stands dismissed for non-prosecution.
Much good.
Item number 18.
yes
May I please your lordship?
yes
Lordship, we could not locate the file, lordship, matter may be pass over for the day, lordship.
as prayed by council for the appellant list of 4 weeks
You oblige, lordship.
Item number 19.
Lordship, I may be allowed to withdraw this. I'm not pressing this, lordship.
Mr.
Was
Kalita,
already-
government council Mr. Kalita
We also did not get any benefit because we retired, man.
there is liberty to withdraw the instant writ appeal hence the same is disposed of as withdrawn. Mr. Chaudhary does not object to the prayer for withdrawal.
Oblige.
Item number 20.
Lordship, in this matter, I am led by the senior counsel D. Sekia, my lord. He had to leave for some urgent work, my lord. Can it be after a week, my lord?
As prayed by Mr. So and so. List after 4 weeks.
I'm obliged.
Item number 24.
Your Lordship, I have some instructions that there has been a settlement between the writ petitioners, the respondents here.
Settlement.
Settlement, but I do not have the papers or the order, my lord. So could it be after? As a one-off case, I represented this state in this
State.
case. So I also do not have, my learned friend has indicated that some,
Okay.
talk of compromise or something is going on. Let us also have the instruction.
And council, Mr.
Matter
So
may
and
be
so,
called after 2 weeks, my lord.
representing the
after review.
respondent submits that he has been informed about the settlement having taken place between the appellant state and the respondents, some kind of settlement. He prays for and is granted 2 weeks time to bring these facts on record. At least after 2 weeks.
Deeply.
Item number 25.
Ms. Chaudhary, you will have to tell us about that matter before 2, because from 2 There's
No,
the,
no, I've already got the instruction, my lord.
okay,
I can just place just now.
yes,
Yes, yeah.
call Mr.
My
Nair.
lord, in fact, my lord, as far as this stipend for the JRF is concerned, it was paid in two installments. First of my lord, 2,24,000 and subsequently 6 lakhs each. I was never paid. I've got the papers, my lord.
The certificate says never
I'm placing it,
claimed.
my lord. There is some communication gap somewhere, but fact of the matter will be cleared, my lord. And we have checked up from our client. She said, my lord, she have received only 2,24,000 and nothing beyond that. And there are documents.
Received is something different.
Yes.
Certificate we
No,
have
no,
filed is
The money,
claimed.
money for the year 13-14 was paid on my lord 14-15. That 22-1-5 later is the money for 13-14. Kindly see, my lord.
Your letter is very clear.
No, my lord, letter is not very clear. That's the whole difficulty. The release of grants in aid to Borlon University in respect of Priti Bosumatre, Asarani Brahma, so and so, for the year 14-15. And my lord, if your lordship will kindly come to third page, serial
Yes.
number 13, that will clarify the position. Just now I've checked out.
Yes.
This sanction is issued in exercise of delegation of power by UGC order dated 28/5/13. So my lord, on 28/5/13, my lord, this money could not have been. So my lord, there was an order whereby this sanction was given pursuant to this order. And my lord, I'll place one more document that will clarify the, I'm reply to page 2.
Yes, yes.
আমার এখন যে পিছন যে 6 লাখ দিলে 6 লাখ যে দিয়ে হ্যাঁ
Page 4.
This is this justified. This amount is 24. That is not still the same.
এখন কি বলতে
4.
All right, Mr. Nair, because this document you just put across the board, we'll ignore it and we'll proceed on. merit.
There is one more aspect that will clarify, my lord. If the
Yes.
lordship will kindly have this affidavit dated 10th of March 21 filed by us, my lord.
Yes.
If a lordship will kindly come to page 4 of that. Kindly see in 2017-18, the second phase was paid, my lord, where my name does not appear.
Very well.
Kindly, this 28th of March 2018, my lord. Kindly see, I am directed to convey sanction of the University Grants Commission
Yes.
for payment of grant of 18 lakhs for 20 years 2017-18 towards JRF, so and so, so and so. Kindly see Priti Bosumatre 6 lakhs 38, grant already sanctioned 2.24.
Mm.
So after 2.24, my lord, 6 lakhs was paid. In between, nothing was paid. Here also it is mentioned 2017-18. It does not mean, my lord, that my lord, for 2017, it was 6 lakhs.
Argument heard, judgment resolved.
Deeply obliged.
Item number
Yes.
5 and 26.
May it please your lordship. In these writ petitions, we are challenging the promotion and supersession of the petitioners and the appellant. And this was dismissed by the honorable single judge on
Yes.
3 grounds without going into the merit on 3 technical grounds basically.
Mm.
We are.
The matter may be adjourned for today. My senior has informed that he has some inconvenience. Lord.
Very well. Let it be on the board. Let it remain on the board, hearing board, or we can give a date.
Lordship.
Very well. Mr. So-and-so submits that senior counsel so-and-so is not available today. Ms. Chaudhary is not available. Who is not available?
D not, Lordship.
D Nath is not available. List. D Nath is not appearing.
D not actually is appearing
For
for the
3 and
rubber
4,
board.
Lordship.
Okay. Rubber board.
Yes.
List for hearing in second week of May. Well,
Item number 29 and 30.
That's all.
yes. Principal.
Made the lordship. Under matter relates to selection and appointment of principal in higher secondary school, my lord.
Yes.
My lord, I have challenged the selection and appointment of the private respondent number 6 on the ground that our B.Ed degree is not a recognized degree by the NCT. And therefore, my lord, she cannot hold the post of principal. My lord, the facts, possibly, advertisement was issued on, my lord, 16/6/2016. Page 28 of the memo appeal. Lord, I have prepared a list of dates and, my lord, the compilation, my lord. For your lordship's reference.
What about the review applications?
My lord, review applications have no connection with this.
No connection.
My lord. Because, my lord, review has been fought against a different judgment, my lord.
Okay. Validity of degree. Hmm. There was a bunch of writ petitions.
My lord.
What happened to the other ones, other matters?
Third part was, my lord, regarding, my lord, removing of the, my lord, private respondent from the post of principal, my lord, on in-charge basis.
No, we are asking you, there were linked cases.
No, my lord, interconnected, my lord, interconnected.
Yes. What happened to the other matters?
Other matter has been, my lord, by this order, my lord, dispose of both the with petitions, my lord. The order under impugn order passed by the single judge, my lord,
All right. There are two writ petitions.
2 with petitions.
Okay. Yes.
The advertisement was issued, my lord, at page 28, lordship will find the advertisement.
Hmm.
Here, lordship will find
288.
note 1. Note 1. The B.Ed degree obtained from off-campus like CMJ, Bharatiya Shiksha Parishad, Navabharat Shiksha Parishad, or any other institute not having NCT recognition cannot be accepted. This is the condition of the advertisement, my lord.
You're reading at page number
28, my lord.
28.
28, just after serial number 5, note 1.
28 of the paper book.
My lord, name of appeal, my lord.
Name of appeal, yes. Yes.
Thus below serial number 5,
Hmm.
my lord, note 1.
Okay.
The B.Ed degree obtained from off-campus like CMJ, Bharatiya Shiksha Parishad, Navabharat Shiksha Parishad, or any other institute not having NCT recognition cannot be accepted.
Right.
This is the condition of the advertisement, my lord.
Hmm.
Thereafter, my lord, the prior to that, my lord, office memorandum was issued by the director at page 29 for the purpose of selection of
Yes.
principal.
Hmm.
Here also, my lord, NB1, the B.Ed degree obtained from off-campus like CMJ, Bharatiya Shiksha Parishad, Navabharat Shiksha Parishad, or any other institute not having NCT recognition cannot be accepted.
Right.
The respondent number 6, my lord. 6 obtained the B.Ed degree during the session 1997-1998 from Silchar College of Education.
Yes.
And the Silchar College of Education was provisionally recognized for the first time on 24/11/1998
Mhm.
for the session 98-99.
Right.
Prior to that, there was no such recognition of the institution by
Yes.
the NCT. And the other two respondents, my lord, they obtained the B.Ed degree from Shashi Bhushan College of Education the respondent number 7, he obtained a BA degree in the year 1996-97. Though the institution, my lord, was recognized for the session 21, 20, 22, 2002, 2001, 2002.
Hmm.
Now, your lordship may kindly take up the NCT Act, my lord.
Yes.
NCT Act, I have given the, my lord, compilation. Where you
Yes.
find the NCT Act, page 1 to 16, section 14 of the NCT Act, my lord.
Does that matter? Oh.
Yes. Hmm. Yes.
Section 14, page 8, my lord. Recognition of institution offering course of training in teachers' education. Every institution offering or intending to offer a course or training in teacher education on or before the appointed day may, for grant of recognition under this act, make an application to the regional committee concerned in such form and in such manner as may be determined by the regulation. Provided that an institution offering a course or training in teacher education immediately before the appointed day shall be entitled to continue such course or training for a period of 6 months if it has made an application for recognition within the said period and until the disposal of the application by the regional committee. Malad, this act came into force, Malad, 1/7/1995. And the appointed date was fixed on 17/8/1995. So, my lord, the existing institution which were offering the BEd degree, they have to make their application within a period of 6 months from 17/8/1995. Up to, that is up to 17/2/1996. Within that period, they have to make an application to validate their BEd degree. Then lordship will kindly turn to page 10 of the compilation, my lord. Section 17(4).
Yes.
If an institution offers any course or training in teacher education after the coming into force of the order withdrawing recognition of subsection 1, or where an institution offering a course or training in teacher education immediately before the appointed day fails or neglect to obtain the recognition or permission under this act, the qualification in teacher education obtained pursuant to such course or training after undertaking a course or training in such institution shall not be treated as a valid qualification for purpose of employment under the central government, any state government or university, or in any school, college, or other educational body aided by the central government or any state government. In clear terms, Malad, NCT Act says that if an institution fails to obtain the recognition from the NCT, then the degree offered by them shall not be treated to be a valid degree.
Right.
Page 131, my lord, of the paper book, my lord.
Yes.
One 131 is a circular issued by the NCT to all the registers of the universities in Assam, thereby restraining the institutions from giving admission to the course during the session 97-98. May read, my lord.
Yes.
As you are aware, all the teacher education institutions should apply to the NCT for recognition. Institution which existed immediately before 17/8/1995 and are still continuing are treated as existing institution, and those which came into existence on or before 17 August 1995 are treated as new institution. The Eastern Regional Committee of the NCT decided that affiliated of an institution, it should have been affiliation, my lord, institution to a recognized examining body during the session 95-96 would be considered as proof of existence if an institution as on 16 August 1995. From the number of applications for recognition received from B.Ed colleges in Assam, it is found that most of these institutions were only permitted to start the B.Ed course by the respective university and were not affiliated to these examining bodies. In this background, the situation with regard to the B.Ed college in Assam needs to be kindly let me know the status of the permitted to start the B.Ed degree colleges vis-a-vis the colleges affiliated to your university. It is pertinent to know whether the B.Ed course are allowed to present their candidates are allowed to sit for the examination through another affiliated college. It is also important to know as to whether the university can permit a college to start the B.Ed course independent of the approval, permission, concurrence of the state government or prior approval of the government is required before permission is given to the college. This information will help us process the application so that the BRC can take necessary decision with regard to the recognition of the 97-98 session only after obtaining NCT recognition. In view of this, you are requested to kindly furnish the above information at earliest and instruct all B.Ed colleges within your jurisdiction not to admit students for 97-98 session without NCT recognition. So, my lord, the private respondent number 6, she pursued the degree during this session when the restraint order was there.
There is a body report which this municipal vigilance. Page number 25 of the chart. What do you say to the NCT stand?
My lord, the NCT has come up with a plea that by a communication dated 29/7/1997, they have extended the last date of submission of application. The last date has been
Not even that. The NCT says that degrees granted prior to 11/8/2003 were valid. So why is the writ court supposed to go into those?
no, my lord, what I am on.
I have to tell them.
No. Prior to 2001. Yes.
Prior to 11/8/2000. It
Yes.
should be 2001.
One. नीचे का paragraph. Refuse to grant recognition. But there is a positive decision. Grant. That is not there.
My case is that, my lord, the NCT itself cannot amend the provisions of the section 14 of the act.
Yes,
If it is to be amended, it is to be amended by the parliament,
right.
not by the NCT itself. They have, by this communication at page 127, they have diluted the provision of the section 14,
Mr. Saikia,
my lord.
you are basically challenging the appointment of the private respondents as principal
My lord,
of the Deshwak Tarun Ram Pokan
my lord,
School in Silchar.
my lord,
Your contention is that the B.Ed degree relied upon by them
my lord.
is
Not
invalid,
recognized,
non-est,
my lord,
correct?
my lord.
Therefore, on the basis of this degree, their academic qualification, that is B.Ed, B.T. and master's degree,
My lord,
they don't add up to the requisite qualification.
my lord,
The learned single judge has held otherwise
my lord.
by taking note of the opinion of NCT and other opinions.
My lord.
Now, if supposing you succeed here, what will happen? They will be thrown out of job and you will get a job. Is that the
No, my
position?
lord, they will be subject to, sir, again.
Hmm.
I will be the principal
No, how do you say?
because they, all the three private respondents, my lord, they were placed as serial number 1.
Hmm.
I was placed as serial number 2
Hmm.
in the select list.
No, what is the date of the select list?
Select list is, my lord, of
This
2019,
principal is by direct recruitment.
my lord.
Appointment of principal
Direct
is by a selection
Direct
process.
recruitment.
So
Selection.
the select list is dated,
Select list is not, my lord,
the selection procedure took place in which year?
2019, my lord,
19.
my lord.
Is that list still valid?
Can't be.
Since, my lord, the litigation are pending since 2019, my lord.
Hmm.
2019, I have challenged the appointment of the private respondents, my lord.
And you have challenged the appointment of 3 private respondents.
No, no, no. Selection of 3 private respondents and appointment of 1 private respondent,
Appointment of 1.
my lord.
You have prayed for a mandamus.
Yes, my lord.
Contradictory stand of
Hmm,
it's contradictory stand of NCT.
understand.
The provisions of the section 14 of the act, my lord, cannot be dilated by the NCT itself.
Yes,
They cannot extend the last date for submission of the application as it has been prescribed in under the act that within 6 months they have to apply. And therefore, my lord, the parliament made an amendment in 2019 by giving retrospective recognition to those institutions which were, my lord, under the government of in India or in any other state governments, my lord. But the present institutions, my lord, they are private institutions. My lord. They are not covered by that amendment also.
Read the provision once again.
My lord,
Section
section 14, my lord.
14.
My lord.
14 is in
Section 14, page 8 of the compilation. my lord.
yes. Yes, please.
Every institution offering or intending to offer a course or training in teacher education on or after the appointed day may, for grant of recognition under this act, make an application to the regional committee concerned in such form or in such manner as may be determined by the regulations. provided that an institution offering a course or training in teacher education immediately before the appointed day shall be entitled to continue such course.
Disposal of the application. So there is no dispute that the application of the Silchar College
My lord,
was pending.
no,
Then
they filed after 6 months, my lord.
after 6 months.
Yes, my lord. Had they filed the application within 6 months, my lord, they could have continued.
How do we
Still
get the
the
date?
application
Where
is
do we
still-
get the date from?
My lord, they have filed the application on 27/5/1997.
And when did the 6 month period come to an end?
17 to 1996.
Okay. How does the single judge deal with this argument?
With this argument, my lord, the learned single judge dealt with page 127. Page 127 is a communication by the, my lord, to the Registrar of Assam University by the regional director, my lord. Thereby, my lord, the last date of application.
Was
submission-
extended. Was
Yes.
extended.
Yes, my lord.
So
Beyond his competence, my lord. He cannot extend the last date, my lord.
extension granted 20 years back. These candidates, they could not have known that the extension would be questioned almost 20 years later. It's a little bit too harsh. And that communication is not under challenge. That is what para 34 reads.
Yes, yes, my lord. Judge of the judgment, my lord.
Yes.
My lord, when the any my lord, executive instruction classes which are my lord, statute, then my lord, perhaps my lord, I'm not required to challenge that executive instruction, my lord, because it is in violation of the statute, my lord.
Para 36. Yes. 2001, it was closed.
So in between, there was a break,
Yes,
2021 to 2023,
yes,
according to NCT.
my lord.
2001 to 3. 2001 to 2003.
There is a break also, my lord, because they could not.
12F. That would give them the power to do this.
The first recognition was granted for the session, my lord, 98-99. And respondent number 6, he obtained a degree, my lord, prior to that. 97-98. And when there was a restraint order by the NCT itself during the session, my lord. NCT said that, my lord, without obtaining in permanent recognition, the institutions are directed to be directed not to give admission for the session.
Act NCT Act. Functions of the church. Yes. Compliance by recognized institutions. Size of that power. Yeah. J also. The power is there.
Who is appearing for the respondents?
I'm for respondent number 6, my lord.
I am for NCT. I am for NCT.
What is your stand, NCT?
Lordship, we already submitted our affidavit, Lordship, in the writ proceeding, Lordship, which also annexed, Lordship. And our lordship submission is that page 198, lordship. Because lordship, that very college's lordship, because after the implementation of that NCT Act, lordship, although that act was new, lordship, so all the lordship colleges are not aware, lordship. So taking into consideration of those aspects, lordship, NCC extended, lordship, that 6 months time limit, lordship. That means, lordship, if they are existing colleges, then they may apply, lordship, even lordship till 99 also, lordship. Recently, I have received one order of the Honorable Punjab High Court, lordship, that date was extended till 99 also, lordship. That meaning thereby, lordship, if within that extended time limit, lordship, if they applied, lordship, then till disposal of that application, lordship,
Deemed to be
they may
recognized.
continue, lordship, their degrees, lordship. So only that, lordship.
This college did apply.
They
There's no dispute.
applied as an existing institute
Existing institution.
in the year 1997. And that was, lordship, provisional recognition was granted. And ultimately in the year 2001, lordship,
The
that
application. was
recognition
dismissed.
was refused, lordship. And again, lordship, in the year 2002, they applied as a new college, lordship.
Yes.
That was a new file.
Yes, lordship, new file was created. So that is the, lordship.
And they got the BA degree in which year?
In the year perhaps 97,
NCT Act.
97.
1997, lordship.
1997. So that is prior to the coming of the act.
After
coming of the act, the petitioner, petitioner.
in that period. where
This is merely a technical ground law. That has been held to be invalid by this noble court also, my lord, in the writ appeal, my lord. That
What?
without recognition, NCT recognition, BA degree cannot be treated to be valid.
It's not a case of no recognition. It's a case of extension for considering the application. That is the case.
Yes, my lord. And the NCT has no power. NCT has no power to grant the, my lord, extension.
Any
That is-
judgment to that effect?
Yes, my lord.
Yes. Let us see.
But page 48 of the compilation, my lord.
Yes.
Page 48. That is, my lord, Rajasthan State Industrial Development and Investment Corporation versus Subhas City Corporation.
We need a judgment on NCT Act itself.
No, my lord, not NCT Act, but I am on the, my lord, executive instruction cannot override the provisions of the statute. The extension granted by the, my lord, NCT, even if it is treated to be an, my lord, executive instruction,
Yes.
still it cannot override the provision of the act. And
Right.
that point, my lord, this judgment was referred, my lord, paragraph 19. Paragraph 19, page 56.
Yes. Redaction.
Lordship, I will give three compilations.
What are you pointing out?
Lordship, what he is submitting, Lordship. NCT Act was established in 1995. Rules for filing application has come into effect on 3/12/1997.
312.
3/12/1997.
Okay.
Without framing the rules, Lordship, thereafter, Lordship, the regional committees are established. Regional committees members were selected subsequently.
Okay.
The application should be filed to the regional committee. If regional committee is not there, there is no question of filing application by the school and universities.
Right.
And that has been decided by the Lordship, Allahabad High Court being division bench. I have pointed out the judgment where
Yes.
division bench has dealt with the matter and said that Lordship will kindly see the judgment I have Lordship relied on. Lordship will kindly see page 16 of the judgment.
Yes, yes.
Lordship, that is the division bench judgment of the Allahabad High Court extra Shukla.
Yes,
Lordship, kindly
16.
page 16 of the compilation, Lordship.
That was what my feeling was. It was a new act. Things are in the state of limbo.
State of flux.
Yes, state of flux, basically. Yes,
Lordship will find page 20, Lordship. These are the appeal against the single bench judgment, Lordship. And last paragraph, it will seem that they are from that the application for recognition has to be made. Application, Lordship got it.
yes, sorry.
Application for recognition had to be made to the regional committee mentioned therein on the basis of the appointed day. A period of 6 months would run out and application would have not made by the month of February 1996. However, council had not nominated the member of the regional committee by the day. And the regional committee came into form 2 months later than the last date of application, that is April 1996.
Yes.
The strict period of 6 months for outer limits, making the application for recognition to be given effect now. None of the continuing institution would be eligible to grant BA degree, and that would be an absurd state of affairs. What happened? What was the last date of making application for recognition was extended by way of executive notification made by the council, and the first date was extended till August 1987. Again, there was another extension. This time, the last date was year 1999. Second extension, last date was fixed on 31/3/1999. If so happens, the Department of Education and University made an application for recognition on the 24th May 1997. Within the extended date has been fixed August 1997. So, Lordship, this ultimately held in the last paragraph. The degree, however, accommodation 97 paid by affiliate college of the university for the year 97-98, 98-99, both faculty of education by the University of Affiliate College is not valid, as the university or college are recognized by the academic session. The qualification shall not be treated as valid degree. Some of the submissions were attempted to
That
be made.
concludes your issues, Mr. Council.
Lordship.
My lord, I have. answered
There
to
was
that.
no mechanism for filing the application within that period of 6 months.
I have answered to that query, my lord.
Yes, sure.
First of all, my lord, my friend's client does not. belong
Forget
to-
about his
my
client.
lord, does not belong to an institution which was existed at the time of coming
Forget,
of the NCT Act.
forget
It was
about
a
the
new
client.
institution.
Mr. Council, it's a principle laid down that within that 6 months period, there was no mechanism to even entertain an
It
application.
was, regional committee was, my lord, constituted my lord, not, the
Judgment,
Eastern Regional Committee, it was constituted in 12 December 1995 itself, my lord. Eastern Regional Committee, under which these colleges are there,
yes,
it was constituted in December 1995 itself, my lord.
very well.
Not,
When did the rules come into force?
Rule notified on 3/12/97.
Procedure for filing application prescribed where?
my lord.
Procedure for filing
In the rule, it
applications.
is not prescribed, my lord.
Okay, let us see.
Not prescribed in the rule, my lord.
Very well.
Obviously,
Let us see.
And Supreme Court has categorically stated, Lordship, without framing rules, that cannot be enforced.
We'll
Supreme Court has-
continue after 2.
my lord.
Yes,
My lord, a new aspect has been,
yes.
my lord, a new aspect has been argued by my lord.
There's nothing new. He has simply cited a judgment. That's it.
My lord, that aspect,
Which
my lord,
lays the controversy to rest.
I'll examine, my lord, Lordship, take up the.
We will examine. You need not.
I will, my lord, think about it, my lord, I'll.
You give whatever you want to give in writing.
My lord, 1 week time may be granted, my lord, next Tuesday. my
Sir,
lord,
we have spent almost half an hour.
my lord,
on the case.
Then, my lord, Lordship kindly come to page 250, my lord. 250, my lord,
1250,
250, my lord.
250, yes.
Yes, my lord. Because this aspect was not,
Yes,
Lord, paragraph 7, it was affidavit filed by the respondent number 6, my lord.
yes.
That as regards the abutments beneath paragraph 7 of the writ petition, the deponent begs to state that the NCT which was constituted by the central government held its first meeting only on 3/11/1995 and has issued the guideline to Assam University on
Yes,
7/12/1995.
Hmm.
It is not that they were not aware about the my lord, act
Okay,
and my lord, the guidelines.
yes,
They were aware about the guidelines and everything my lord, by 7/12/1995.
yes,
So my lord, that plea that they were not aware about and the guidelines were not there may
Hmm.
not sustain my lord.
yes, okay. Very well. Okay. Arguments heard, judgment reserved.
My lord, one more aspect, my lord, may I plead my lord. The respondent number 7 and 8, they, my lord, pursued their B.Ed degree from Dr. Susi Bhushan Institute of Education, my lord.
Yes,
That institution was not an existing institution.
Hmm.
So, my lord, that benefit of proviso to section 14, they are
yes,
not entitled to.
very well. We'll consider. Thank you. Yes,
Finding of the review was basically the same, which was started and originated in the year 2016 in percent advertisement. Where the review petitioner was appointed as a principal of a college, in which case, my lord, the current institution, that is, my lord, Teacher College of Education.
yes,
She was a candidate for year 1998.
Hmm.
I'm not going to the background matter. Simply matter, we are relying upon the judgment which was passed by the honorable single judge, which is under appeal matter.
right.
If the Washington State could allow the appeal, then we'll have to argue. If it merits the-
So we'll post the review to a subsequent date.
Yes.
Okay. The review application shall be considered after disposal of the appeal. Okay.
I'll file an-
Yes, yes, madam.
My lord, Supreme Court judgment, 2010-13 SCC,
Yes.
page 203.
What is the
State of
issue?
Uttar Pradesh.
Yes,
Issue, my
I
lord,
have
that,
given the judgment.
from the date of application, once somebody applied, if the application is pending, para 30, your lordship, may kindly see.
yes,
If the application is pending, then they are, my lord, capable of. They are, my lord, entitled, to, my lord, page 30, my lord. Not page, para 30, my lord. This is, my lord, then, NCT made it stand clear as
Yes.
evident from the impugn order that after the enforcement of the NCT Act, the existing institution on the appointed day offering a course or training in teachers' education are entitled to continue such course or training, provided such institution applied for the grant of recognition under section 14(1).
That the section itself says.
Within a period of 6 months.
Section itself says.
Yes, madam. Section itself says, madam,
Yes.
that it is reconfirmed by the Honorable Supreme Court, my lord.
Very well.
And your lordship may kindly see if anything, my lord, the NCT Act, my lord, section 12.
Hmm.
Its power is, my lord, defined there.
Let's see. मुझे पता है। मैंने बताया था ना। Yes. 12, which sub clause?
Section 12 of the NCT Act, my lord.
Yes.
That is, in my book, it is in page, my lord,
No, it's which clause you want to read?
section 12, functions of the council.
Yes,
Here, my lord, that they have so many, my lord, that D lay down guidelines in respect of minimum qualification for a person to be employed as a teacher in schools for recognized institution, lay down norms for any specified categories.
yes,
And so many powers have been given, my lord, to for betterment of the, my lord, education. They can, so many clauses are in favor of them, my lord.
yes,
Lay down any specific category of course or training in the teacher education, including the minimum eligibility criteria for admission thereof and the method of selection of candidates during the course. Lay down guidelines for compliance of recognized institution or starting new courses or training for the providing physical and instruction facilities, staffing pattern and staff qualification. It lay down standards in respect of examination leading to teacher education qualification. criteria,
what particular
and so on,
clause you want to point out? What is this? Where does this lead you to?
Beg your pardon?
How does it help you?
My lord, they have got for the betterment, certain clauses.
Okay, does it give any power to the NCT?
Betterment,
Does it give any power to the council?
my lord,
To
they are
extend the
assailing
time?
power. Assailing the power whether they can give extension for that.
So does this section have any indication that it gives power of extension?
Not my lord, exactly power, but they
Then-
have got the power for betterment of the my
Very
lord,
well.
teacher education. The certain clauses are there, my lord.
Okay, very well.
I move permitted to file an additional written argument, my lord. I move permitted to file an additional written argument, my lord, by Monday,
Additional?
written argument, my lord. I will file by Monday, my lord.
Okay, you'll do it.
My
Maybe.
lord.
Arguments are judgment reserved.
Obliged, my lord.
And he has not assailed the, my lord. He has not assailed in the repetition, my lord, assailed the extension order. He has not challenged the certain.
Okay.
Obliged.
Can you give a brief written submission mentioning this fact?
Yes,
Please do that. Yes, thank you.
obliged.
Giving the judgment, without framing rules, the act cannot be enforced. That is also 1995 QSCC 348. Para 20.
20.
Moreover, the act and rules form part of the composite scheme. Many provisions of the act cannot be into operation only after relevant provision of the form prescribed in the rules. In absence of rule, act cannot be enforced.
Supplementary to STC.
Para 20 last, middle part also. In the absence of rules, the act cannot be enforced.
Yes.
Obliged.
Okay.
Item number 13, passed over, madam.
Yes.
We consulted our party. The thing is, my lord, an apartment, my lord, whose market value is not less than 60 lakhs. An apartment whose market value is, my lord, not less than 60 lakhs. But she is occupying, but it is not in her name. But we would see that, my lord, the property is registered in her name.
She's residing in that
She is there,
apartment.
she is there. Is that, but we would see that it is registered in her name at our cost. This is the first thing we offered.
Mhm.
It is not less than 60 lakhs. They say it may go even up to 75 lakhs. We are not bothered about it. But,
Okay.
it's a substantial work.
Yes.
And apart from this, a cash of 5 lakhs has also been offered. Now it is for them to take a call.
What do you say, sir?
I'll take inspection, my lord. I do not know, my lord, because that has been just now, my lord,
Okay.
referred. My lord,
No, please.
let them sit together, my lord, decide whatever they make the payment, my lord,
The sitting
This
together,
is
it is not
An
possible.
offer which is coming out.
Yes, my lord.
Is your client agreeable or not?
My lord, I have to take her instruction, my lord.
All right,
And
take down. After addressing the court for some time. And upon intervention of the court, when counsel representing the parties, took instructions from their clients to explore the possibility of an amicable settlement. Then senior counsel representing the appellant submits that the respondent is presently residing in a flat owned by the appellant.
That word, madam. Flat matter, we would see that that flat goes to her name.
Who is the owner of the flat?
One of the company, some company.
He is residing in a flat which is owned by a company with which the appellant has direct connection, and that it shall be ensured that the flat is transferred to the name registered in the name of the respondent. In addition thereto, comma, the appellant is ready to offer a sum of rupees 10 lakhs,
5 lakhs.
10, 5 is pittance,
Leave it to lordship, leave it to lordship.
10
Yes.
lakhs to the
Because if I have to
respondent.
come again, then they have to pay me fee also, we would pay. that.
Yes, he should be better advised.
Yes,
10 lakhs to the respondent as a one-time settlement.
sometime.
And counsel for the respondent pays for some time to complete his instructions on this offer made by appellant's counsel. Re-notify on,
10 lakhs is, then they would come up for more money, my lord. So 5 lakhs may be recorded, then they would get an, they would come
Okay.
for more money. That is the
5
difficulty
lakhs.
for us.
okay, 5 lakhs.
He's having three institutions without several properties here in Barpeta, everywhere, my lord.
Yes,
And he's now, my lord, member of.
we'll step in, don't worry.
My lord.
Once you agree, we'll step in, don't worry.
My lord, that's true.
Okay.
My lord, that intervention will be required.
We'll intervene.
My lord,
List on 27th.
After Bihu vacation.
But some big vacation comes, my lord, after that's what. Huh?
Very well.
20
It's up to you.
So I don't know.
25th April.
Much up, much up. Yes,
Registered in the name of respondent number 4.
Respondent number 4.
yes, yes. At our cost, my lord. Cost would also, we would bear the cost, my lord. At our cost,
Of course.
he need not pay anything.
Very definite.
That value is not that much, my lord. Anyway, but I'm not making. it.
No, if
That
she's
value-
not willing, we would
value is
say-
not that much, that.
No,
what
if
they are saying. Anyway, my lord, I'm
if she is not willing, we would see that it is sold and that 60, at least 60 lakhs, it would be in her hand.
Anyway, my lord, at this stage, my lord, I would not make any comment, my lord, not.
Very well, very well.
Not proper. Much obliged.
Save your submissions for the next date.
Yes, my lord.
Thank you.
Item number 15 and 16.
Now we can leave these hearing matters. We can get on with that bench. Okay. Yes. Is this covered?
It's covered.
Very well.
The same batch of
ठीक है. Allowed in light of so and so.
Now matters
This is the
dealing with environment. Item numbers 1, 2, 3.
But these matters, my lord, pertains to encroachment and eviction in a wildlife sanctuary, namely, my lord, Amsang Wildlife Sanctuary, that is in the eastern boundary of Guwahati, my lord.
yes.
We, my lord, conducted a massive eviction drive, my lord. Eventually, my lord, what came out, my lord, there were claims that, my lord, we are conducting eviction inside revenue areas also, revenue land. So at that stage, my lord, government decided to go for a mapping by Survey of India, my lord. The
Okay.
Survey of India, last year, my lord, has submitted a map. And that map is so large, my lord, it includes so many institutions, police stations, army camp. So we have to again do it on our physically verify.
Exercise.
So
Yes.
we have prepared a list, my lord, which institutions will be touched by this eviction. If we
Okay.
go by the Survey of India map,
Mhm.
and it is now being placed at the highest authority of the government.
Okay.
So some time will be required, but it will have massive repercussion, my lord.
Mhm.
If I may submit the list, my lord, even army camp at, my lord,
List is there.
list
We
of
have
my-
the list.
list of the properties or the institutions that will be touched, my lord.
Yes.
It's huge, my lord.
True.
Army watchtower, even Jorabad police station also comes inside it. So whether state will accept the Survey of India map or will confine to our own original map. my lord.
So how much time do you need to come out with a
At
fresh
least-
proposal?
At least 6, 8 weeks, my lord, because
8 weeks.
Milord, one thing I would like to, Milord, the Survey of India thing is, Milord, perhaps it is of last year, Milord.
Yes.
Since last
That
year,
was
Milord,
big.
this is, this submission has been made that we'll reconcile with the map of the Survey of India and come to an independent decision. There were
Yes.
directions of this honorable court, wherein this honorable court said that let the map of the forest department as well as the Survey of India map is
Be
reconciled
compared.
by the forest department and come to a conclusion.
So do it now in a reasonable time.
my lord will kindly peruse the last order of your lordship, 1/2/2023, my lord.
1 to 2023. Yes,
The forest department has raised an issue that the demarcation survey made by the Survey of India is in conflict with the information available to the forest department as regards the area to be
yes.
the forest area. In view of the above, the Survey of India may look into the original notification by which the reserve forest was created, undertaken, and boundary thereof, and with their report as to whether any such discrepancy in fact exists or not. Aforesaid exercise is required in view of the soil.
Yes.
So, my lord, we are doing it that, my lord, it will take some time,
You were given 2 weeks. Now we are 6 weeks down the line.
my lord.
How much time can we give you?
My lord, may I take the assistance of the principal chief conservator of forest? He is
Sure.
personally present, my lord.
Sure, sure.
Okay.
Yes. You take instructions and let us know.
Well.
Finally, how much time is needed?
To act on the.
Lordship, if you look at the map,
You know,
our
you will.
Lordship, our line is on the north and the Survey of India line is on the south. And in between, Lordship, lot of existing settlements have come, which includes
That-
the
Your council has already told us.
Lordship.
If you want a resolution of this
Situation.
contradictory situation, you come out with a proper report. How much time is needed?
Lordship, give us at least 2 months' time, we'll get back on.
1.5 months has already passed from the previous date.
Lordship, our
We can't
survey
give
is
you
complete.
indefinite time for this.
End of April, Lordship, that's what I wanted to mean.
Sensitive.
That's all.
ठीक है,
Lot of it.
लगाओ, time लगाइए.
So some evictions have already been carried
Yes,
out.
my lord,
in
that was, my lord,
2018.
2017-18, my lord.
17, 18.
Huge repercussion, my lord. School students were, my lord, affected. That's why, my lord, we were compelled to stop for that, for time.
There are more encroachers.
Still more encroachers. And if you go by the Survey of India map, my lord, it is not only encroachers, huge, my lord, establishment, educational institutions, army camp, everything comes in, my lord.
This is the
Lord,
list.
Lord, but my submission is that whatever is there in the Survey of India map, because the boundary of the wildlife sanctuary, if your lordships kindly take up the PIL, it has already been earmarked. So forest department can very well compare both and come to a definite conclusion.
That's
because
what we are
until
directing them.
Other way, the
Yes,
conclusion has to be there. We cannot go on like years together
yes, true, true.
for coming
Absolutely.
to a conclusion. That is what my submission is, my lord. Because Survey of India, if it, my lord, 1 year back it was filed, my lord.
Yes.
7/2/2022, the Survey of India.
Mr. P. N. Goswami, learned additional advocate general.
There is one little perspective, my lord. Item number 2, that is WPC 415 of 2018. There, our perspective is slightly different, my lord. Our grievance is without following the procedure prescribed in section 26 capital A of the Wildlife Sanctuary Act, my lord, our area has been included in the wildlife. So that is our contention, my.
So we are not presently adjudicated about that. We just want to resolve this issue regarding contradictory.
It's an ancillary issue, main
Yes.
issue is there.
Yes.
So learned additional advocate general. Appearance for the official respondent submits that the map prepared by the Survey of India is too broad and includes several
Institutional.
areas,
Yes.
which is posing difficulty for the government to come to a conclusion as regards the area that would be covered under the Amsing Wildlife Sanctuary. As such, Mr. Goswami pays for and is granted further 8 weeks time to examine the matter and resolve submit a proposal for resolving the issue. Mr. M. K. Yadav, principal
PCCF and head of forest.
PCF and PCCF.
And head of forest.
Head of Forest is personally present. The other issues will be considered at the matter.
My lord, they will come up with a final decision on the next date, my lord. Perhaps.
Record that.
On the next date, the department authorities are to come up with a final proposal in the matter.
My lord.
Obligation.
Item number 4. My lord, this is a case, my lord, about garbage dumping. Certain citizens from, my lord,
a township in Upper Assam, Dibrugarh, they have filed it. And then the locality, my lord, suffered. And on the last occasion, your lordship, my lord, perhaps rightly said that this will not be taken as a one-off case. There will have to be. Today, my lord, the deputy commissioner, we have been served with my junior has been served with an affidavit filed by deputy commissioner Dibrugarh. It speaks some good things, my lord. Let me say fairly. Page 3 of the affidavit filed today.
Copy has not come.
And lordship was telling me that shifting of garbage dumping ground will not solve the pollution. Scientific approach will have to be taken. And if necessary, lordship was also proposing for constitution of an expert committee, including some highly technician from IIT and something, some institution like that. Paragraph 4 of this affidavit, they say the garbage dumping activity at Maijan, as your lordship got it, ended in the month of August 21 after inauguration of solid waste management plant at Lekai, Thakurgaon, Dibrugarh. Then paragraph 5. At present, all the municipal solid waste produced are collected at Dibrugarh and transporting, unloading, processing at the solid waste management plant at Lekai. Then paragraph 7. Department as well as municipal authorities are considering to take up a project for bioremediation. Malad, being a non-technical person, I may not be following certain words, malad and procedure, technical procedure. Of the legacy dump site at Maijan, it is on the bank of Brahmaputra, my lord. For covering it to the parks, etc., accordingly necessary DPI has been prepared. If this is good. These are, I must say that some good things have been spelled out in this affidavit, but I don't know about the ground realities.
Disposal of waste already fixed. The mere dumping, it's used maybe for generation of.
Yeah, please, next case to Ekadon and.
Full observation.
And what?
AG said.
Environment.
I don't know in this matter also. That will explore. Let us. AG notice. Let us get statistics for all districts of. You know, we do.
This affidavit has been filed this morning.
Yes, Lord.
Today.
After 12 years.
Today, my lord, I don't know about the ground realities. It sounds good to some extent. I don't know whether it has been, my lord, followed. A management, how the management plant is working, if at all it was set up. I don't know, my lord. Ground realities are at times different. Your lordship has seen for a time.
Just provision. Suggest.
Yes, the counter affidavit filed this morning by the respondent number 7 is taken on record. According to the statements made in the affidavit, the problem regarding garbage dumping appearing at the Maijan dump site has been taken care of. However, taken care of. Mr. A.C. Borbora, Learned Senior Counsel for the petitioner, seeks some time to obtain instruction on the affidavit. However, having regard to the materials on record, we are of the view that not only the garbage dumped at Maijan, but the state is required to come up with a comprehensive policy and a mechanism not only to dispose of garbage, but to use those beneficially for
Possibly for power generation.
Possibly for power generation. Since such technology is now available now available.
And in use.
Available and in use in various countries, full stop. So as to explore the possibilities of expanding the scope and ambit of this procedure so as to cover all the districts in the state of Assam. We would seek the assistance of the Advocate General Assam. The learned AG Assam is therefore put to notice. Copy of the writ petition and the affidavit be furnished to the office of the learned AG Assam. Let this matter be listed again after 6 weeks. 4 weeks.
Let's have it on.
1 minute, my
4th.
lord.
Yes, yes. We'll be putting court. Thursday court, Thursday.
My lord, about me taking instructions, about the garbage dumping place, that's all that, but functioning of the, my lord, solid waste plant and all, my lord, it will be difficult for me to obtain whether, how they are functioning.
We'll get them.
20.
First, let's have it on. 30th first, 30th March, 4 months.
Let it be after
30th March.
Bihu. 30th March. It's fine.
Let the AG come, then we'll very important.
30th March, 30th.
Deeply applied.
Item number 5,
One more few question, and then we'll ask it. Again, same solid waste
Regarding,
management.
yes, liquid and solid waste management project, my lord.
Yes,
It is now in a final stage. The DPR has been prepared and
for
DPR prepared for the project and it was sent to the Assam Engineering College for vetting.
Mhm.
After getting that, then after administrative approval, the project, NIT will be floated and project will be started.
What is the proposal?
Proposal for my lord, construction liquid, solid and liquid waste management. This in Shivsagar Municipal Board.
In what manner, sir?
This manners, my lord,
Where is the DPR?
DPR that has been sent to my lord, sent for vetting.
We want to see the DPR.
My lord.
Bring it on 30th.
30th. My lord, after
Yes.
getting from the some engineering college,
We get a copy,
yes, my lord.
even a draft
Yes.
on 30th, list on 30th,
30th along with the other.
along with the other matter. 30th March.
item number 6 to 12.
What are these supposed to be?
May it please, your lordship. My lord, I am appearing in item number 7, my lord. Basically, my lord, we have highlighted, my lord, the decline in forest cover of the state, my lord. My lord, whatever happened had happened. Let state take this not as an adversarial litigation, my lord. In fact, on last occasion, I suggested the name of Mr. Jadhav, my lord. He is a very dedicated and committed officer.
Yes.
So I'm sure, my lord, you will offer a solution to this problem, my lord. And we are not here to blame anybody. Whatever had happened, had happened. My lord, basically, my concern is, my lord, this deforestation, rapid urbanization, how this can be regulated. My lord, of course, my lord, the development is also required.
That's true.
Therefore, my lord, we can, in the name of protecting environment, we cannot, altogether lose sight of development. So sustainable development should take place. My lord, certain activities need to be regulated, my lord. For example, my lord, Guwahati is surrounded by a lot of hills, my lord. Now, hill arts is also required for development activities. Why not state say that this is the particular area which will explore, others can't be. Frequently things are going on. So, my lord, some form of regulation has become very important, my lord. So I'm sure my lord, Mr. Jadhav will, my lord, come up with some solution. So basically, this is my perspective, my lord. My lord, I'm just relying on one, my lord. Kindly see, my lord, what is the extent, my lord, things have gone.
Yes.
Kindly see, my lord, where the chief minister himself has emphasized northeastern region of the country has lost around 4350 square kilometer of primary forest area in the last 2 decades, that is 2001 to 21, which is nearly 3 times the size of the Delhi, having an area of so and so, according to data of Global Forest. Then my lord will kindly come to the next subpara. According to data, the Arunachal Pradesh has recorded highest degradation in forest cover, that is 1250, followed by Tripura and Assam 630. In the last 2 decades, resulting in climate change alarmingly. Now please come to the last para. The Chief Minister Sri Himanta Biswa Sharma on Sunday said, loss of forest cover is a major reason for natural calamities like flood, called for a larger role of the forest department in reclaiming forest cover through plantation, clearing, encroachment, working in coordination with local people to address the issue. He said the forest department over the years has focused mostly on Kaziranga National Park, while there was need to focus on other forest areas as well. This has led to depletion of the forest cover due to deforestation, encroachment, and so on. The forest department now should focus towards reclaiming the forest cover, he said. So basically, my lord, if government, my lord, should translate this, my lord, wishes into actual act. That is my only humble submission, my lord.
Lordships, I would like to crave attention of the Lordship to one small fact. Lordship, in 2002, we did an elephant population estimation, and it was found that there were 26 elephants which were residing in revenue areas outside the forest and protected areas. Lordship, when this was repeated in 2008, the number of elephants that came down that were residing in the revenue areas, Lordship, was 146. Today, Lordships, in April 2nd week, we are again doing this elephant census operation. And I'm sure, Lordship, that the number would be almost 3 to 500, likely. Now, the question, Lordship, is that if I assume that the total elephant population in the state is 6,000, then 500 or 300 is a sizable number. Lordship, if you look at our learned council has raised the issue, Assam Bachao, definitely it's a very valid issue. But if you look at the causes of why we are here at this stage today, Assam, Lordship, is surrounded by neighboring states. All our forests are, Lordship, on the borders of Arunachal, Meghalaya, Mizoram, Nagaland. And one of the major causes of this loss of forest cover has been, Lordship, that these states have been, as a state mechanism, encroaching upon the lands, and we lost several, I think, Lordship, about 600 to 700 square kilometers in Golaghat district due to Nagaland. We lost, Lordships, quite a bit of area in Arunachal, Lordship. I have some photographs, your Lordship, to share that.
We are not on settling the boundary disputes on the state.
No, Lordship. My point is that
Guwahati High Court is concerned, it exercises jurisdiction over all 4 states. So if the forest cover is being depleted there, even they are answerable. Nature is not bound by the boundaries created by human beings.
Right, Lordship.
So we have to address everything.
Right, Lord. So that was one reason, Lordship.
Yes.
Second reason, Lordship, has been mainly in the North Bank, where we have large number of elephant populations, and forests have been occupied by people by cutting large chunks of forest.
Yes.
And the department has tried, but I would say that we could not stand up to the large population.
We will ask you a simple question.
Lordship.
Is your department equipped by manpower and equipment to tackle these issues? Simple question and straightforward answer.
Lordship, we had a lot of vacancies in the department. This year, the government has decided to fill all the vacancies. So by May, these vacancies will be filled up. And Lordship, we are raising a new battalion of 1,100 strength. So that would give a great fillip to our the force to protect the forest, Lordship. So I think we will be better strengthened, Lordship, in this regard.
Mhm.
We have done evictions, Lordship. If you look at that sheet, already our government has evicted, Lordship, in Lumding. In the second page, Lordship.
Is eviction drive the only measure which will serve the purpose? Is there a corresponding effort to replant the trees which have been cut down?
Yes, Lordship. This year itself, we have taken a target of raising, Lordship, 10,000 hectare of forest.
Forest.
Last
Okay.
year, Lordship, we raised 2,000 hectares of forest with 70% survival with the help of the fringe communities on the forest, what
Okay.
we call joint forest management committees.
Yes.
It's a very successful, Lordship. So this
Mhm.
year, 10,000 hectare, Lordship, is the target to be done in this, what the Learned Council has been talking about, the vacant forest areas, Lordship. So that we are taking up.
Okay.
And the whole target, Lordship, is to increase the forest cover by 2%.
Then we fund this petition to the neighboring states. Right? Can you bring all these facts on record on an affidavit? More
Yes.
particularly, the loss of forest on the boundary areas,
Lordship.
so that we can expand the scope of this. Yes.
Lordship, that will be great.
Please file an affidavit on 30th. By 30th, these facts should be brought on record to an affidavit.
Yes, Lordship.
My lord, my only submission is, let a continuing mandabas be something like that in Goda Burman's case, my lord. I think that will be, my lord. Yes. Yes. Sure.
MK Yadav.
MK Yadav, Chief Conservator of Forest
Principal Chief Conservator of Forest and Head of the Forest Force.
and Head of the Forest Department. Force is present in the court for assisting in this PIL of great public importance, as the same seeks to address the burning issue of loss of forest cover in the northeastern states. Mr. Yadav has made certain oral submissions which he would like to be brought on record in form of an affidavit. It will be done by next date of hearing. Re-notify on 30th.
Thank you.
Deep privilege.
With due permission of your lordships, reference will be made on the passing away of late Durlabh Chandra Mahanta, senior advocate and member of the Guwahati High Court Bar Association. For order of reference, may I call upon Mr. Dilip Chaudhary, President, Guwahati High Court Bar Association.
Honorable Chief Justice, honorable judges of the Guwahati High Court, respected members of the registry, honorable seniors of the bar, and honorable members of the Bar Association of both the association. This is a sad occasion that we have assembled here to mourn the demise of elderly one of our fraternity on 20th March 2023. And he is Durlabh Chandra Mahanta, senior advocate of the Guwahati High Court, a man of principle, devoted entire life for the poor masses, either in his socio-political activities of his young days or in the legal profession by taking up the causes of the poor litigants to have them justice. Late Durlabh Chandra Mahanta hails from Koronga of Jorhat. He hails from a family of Sattradhikar of Telpani Satra of Gondia village of Koronga. He was born in 1932 at Koronga of Jorhat. He started his child life with his grandfather. The Sattradhikar of Telpani Satra at Gondia village, he was brought up. He started his schooling at Rangajan ME School. After ME level of education, he started his high school level education at Jorhat in 1947. Though his upbringing was in the atmosphere surrounded by the spiritual activities, but in face of his mind towards the communist ideology was an exception in his life and his family. He joined Communist Party of India in 1949. In 1950, while administration became tough against the Communist Party of India during 1950, he was sent to jail for his left activities. Durlabh Chandra Mahanta started his social activities from his childhood, and while he was a student of class 8, he was a secretary to the Young Socialist Club at Jorhat. He joined JV College of Jorhat in 1952 as an intermediate science student, and he passed this course in second division in 1955. Thereafter, he came to Guwahati for his higher study and joined in Cotton College. He got his higher education at Cotton College, and he was graduated from this college in 1957. He got LLB degree from Guwahati University in the year 1968, and he joined as advocate in the Jorhat Bar Association. After about 10 years of his practice in the subordinate courts at Jorhat, he proceeded to join as an advocate in the Guwahati High Court. He was designated as senior advocate in 1999. Late D.C. Mahanta, whom I had seen in the court and bar association activities, was a very strong personality. He fought for the justice, and to achieve this just and proper was the motto of his life. He was chairman of disciplinary committee of the Guwahati High Court Bar Association during 2004-05, and members of the committee were former Judge Hunima Hazarika and myself. He was the son of Mohan Chandra Mahanta, an advocate and a politician. His father was secretary to the District Congress Party at Jorhat, and he was a member of the local body of Jorhat. He lost his eldest son about a decade ago, and his wife left his company for ever some years before. He left behind one daughter, son Sri Tanmoyjyoti Mahanta, senior advocate of Guwahati High Court, and Sri Dibyajyoti Mahanta, an engineer who stays abroad for his service at Boston of America. Late D.C. Mahanta was with multifaceted activities for being famous in the society. He was a socialist from his high school time, a communist since freedom movement, though his family members were from the Congress Party. He had shown his reluctance in easygoing life and had embraced the tough ways of life for the society. He has made his way of life to live amidst us always, with his memories forever, even after his demise. I, on behalf of myself and on behalf of the members of the Guwahati High Court Bar Association, pay homage to the departed soul, and I convey heartfelt condolence to the bereaved family members, and we share the grief of them.
Mr. Satyadhar Matak, President, Guwahati High Court Advocates Association.
Honorable Chief Justice, honorable judges present, respected members of the registry, respected senior members, and my colleagues of the bar, ladies and gentlemen present. Today, we assemble here to pay tribute to late Dulabh Chandra Mohanto, a nonagerian senior member of the Guwahati High Court Bar Association, who breathed his last on 28th March at 91 years of age. Late Dulabh Chandra Mohanto was born in 1932 at Telpani Khotra of Koronga, Jorhat. Having graduated in science from Cotton College in 1957, he served as a science teacher of Sinamora High School in Jorhat. After getting law degree in 1967, he first joined the Jorhat Bar for practice, and a few years later shifted to Guwahati to practice in the Guwahati High Court. He was designated as a senior advocate in 1999 by Guwahati High Court. For his brilliant career in the advocacy. Besides his legal practice, Mr. Mohanto was very closely associated with many social organizations. A good number of them are from his native district, Jorhat. Due to his long, consistent efforts, together with some of his colleagues, including one Dr. Girish Borua, a retired professor of Jorhat, he established the Sinamora College of Jorhat, of which he became the founder president of the college managing committee. The Sinamora College Authority has erected a bust in front of the college in his honor. On his death, we have lost a great legal luminary of the Northeast. He left behind two sons, one of which, Mr. Tanmoy Mohanto, is a senior member of Guwahati High Court Bar. I, on behalf of the Guwahati High Court Advocates Association, pay my respectful tribute to the departed soul and convey my heartfelt condolence and sympathy to the very family. May his soul rest in peace in heaven.
Mr. Chinmoy Chaudhary, Chairman of Bar Council of Assam, Nagaland, Mizoram, Arunachal Pradesh, and Sikkim.
Honorable the Chief Justice, Honorable Justices of our High Court, the members of the judiciary, the registry, my dear colleagues in the bar. The full court reference is organized today to condole the demise of a doyen of the Guwahati High Court Bar Association, late Dulabh Chandra Mohanto, who passed away on 20th instant. The great soul passed away after a brief illness at the age of 91 years. Late Mohanto sir was born in 1932 in a lawyer's family at Jorhat. His father, late Mohan Chandra Mohanto, a prominent civil lawyer of Jorhat. Father Mohan Chandra Mohanto is a true Gandhian and a freedom fighter. Mohanto sir, after completing his matriculation in the year 1952 from Shankardev Seminary School, did his ISC from JB Law College, Jorhat, JB College, Jorhat, sorry, in 1955, and graduated himself in the science stream from Cotton College, Guwahati in 1957. After a short stint in ONGC on 1st of August 1959, sir got engaged in the teaching profession and taught in Bedbury, Rangajan, Sinamara High School at Jorhat. He was the founder, headmaster of Sinamara High School. Sir went back to college and obtained BT degree. He got his LLB degree in 1967 and joined bar at Jorhat in 1968. After a decade's practice at Jorhat, Sir shifted his practice to Guwahati on 2nd January 1978. Sir was conferred the senior designation in 1999 by the Guwahati High Court. Apart from his practice as a lawyer, Sir used to take keen interest in political field as well. At the age of 17, Sir joined the Undivided Communist Party of India in 1943. Sir was a strong believer in the philosophy of Mahatma Gandhi and Karl Marx. Sir was always preferred to remain in the forefront of people's movement, espousing the cause of poor, rural masses and the downtrodden section of the society. As Mahanta Sir continued to work for the upliftment of the working classes, he was arrested under the Defense of India rules and was detained in Tezpur jail in August 1960. Thus, Sir was active in the socio-political life. Sir retired from profession in December 2010 after a prior announcement that he would not continue in practice with effect from 1st of January 2010. Sir grew up under the able guidance and control of Sri Jadav Chandra Guhai, the Sattradhikar of Telpani Satra. At the later part of life, Sir was greatly influenced by his paternal uncle, led Dodhi Mahanta. Because of his Satra background, Sir was conversant with singing of devotional songs and had developed the habit of reading chapters from the religious books like Kirtan and Namghoka every day. During the Assam movement, Sir had played crucial role as a social engineer and was the mastermind in drafting the petition challenging the validity of infamous IMDT Act, which was enacted for protecting the interest of the foreign infiltrators from the neighboring state. With his effort, the said act was declared unconstitutional by the Honorable Apex Court and the same was repealed. Sir was an author and had several publications to his credit. Sir had lived a married life spanning over 60 years and had left behind his wife, elder son Tanmoy, who is a practicing senior lawyer of this bar, younger son Dibbajyoti Mahanta, by profession an engineer, who stays abroad apart from a host of relatives and well-wishers. I, on my own behalf and on behalf of the Bar Council of Assam, Nagaland, Mizoram, Arunachal Pradesh and Sikkim, offer my homage to the departed soul and pray to the Almighty that his departed soul may rest in peace. Also, I pray to the Almighty to bestow enough strength upon the bereaved family to bear the loss.
Mr. Dilip Mazumdar, Additional Advocate General, Assam.
Honorable Chief Justice, the other honorable judges of this honorable court. Today, my lord, we have assembled here to mourn the sad demise of Durlabh Chandra Mahanta, a senior advocate of this bar. Late Durlabh Chandra Mahanta, born in Jorhat, was the son of late Mohan Chandra Mahanta, who was also an advocate and a freedom fighter. He graduated from Cotton College, Guwahati, initially took up teaching as a profession and simultaneously involved himself in serving the cause of the working class and was also an office bearer of a recognized trade union of India. Later in the late 60s, he graduated in law and joined Jorhat Bar in 1968, and after a decade, he shifted to Guwahati and pursued the legal profession in Honorable Court and his various other subordinate courts and tribunals. Because of his involvement in the struggle for the mass, he was detained in Tezpur jail in the year 1960. I have no hesitation to say that Mahanta Sir, who was out and out an honest man, did not get swayed by the allurement of extravagance that he could afford with the kind of ability he had as a lawyer. but instead he chose to adhere steadfastly to the strict principles of social values, devotion to the service of the poor and marginalized people, contributing to the education of the people of his hometown, in addition to pursuing the teachings of great Saint Srimanta Shankardev. And this is the legacy he has left behind for the progeny. Late Mahanta left the profession in December 2010 and involved himself in various socio-religious activities thereafter till he breathed his last on 20th of March 2023. Late Durlabh Chandra Mahanta left for the heavenly abode at the age of 91. At the time of his death, he was survived by his wife, I am told, 2 sons and a daughter, one of whom is our colleague Sri T.J. Mahanta as Senior Advocate of the Bar. I, on behalf of myself and on behalf of the state of Assam and its people, offer deep condolences to the bereaved family and sincerely pray for the eternal peace of the departed.
Mr. Diganta Das, Advocate General, Mizoram.
To the Honorable Chief Justice, other accompanying justices of this Honorable Court, members of the registry, senior advocates, members of the bar, and ladies and gentlemen. My lord, a very sad day for us. We are missing a legendary and doyen of our High Court, namely late Durlabh Mahanta sir. My lord, I remember in the year 1985, when I joined, my father was a part of the bench. He advised, don't come to High Court, practice in the trial court. I was practicing in a trial court and I pursued my father that you should give me a motorcycle. My father said, why you want a bike? Why you want a scooter? You can go by bicycle. You can go by rickshaw. Somehow I pursued to my mother I could get. My father was saying, you go to our High Court and you'll find a lawyer whose name is Durlabh Chandra Mahanta and he comes in a bicycle. I was a bit surprised whether he's saying correctly or not, or just only for the purpose of the bike. Then, my lord, I came in the High Court, this old building, and I was shocked that sir was riding a bicycle when he comes to the High Court. And I went back and I said, you are right. He's a bicycle. He said, not only that, you go to the court and watch him. He is a man of honesty. My lord, I was so lucky. 85, thereafter I joined. Most of your lordship who is elevated from the bar to the bench, definitely they know. Most of the judges, they know, sir. So honest, my lord, whenever there are court cases, I have witnessed. And whenever the judges are asking some question and he finds other side, there is a case, I don't have a case, he will say, sorry, my lord, I'm conceding I don't have a case. I think this is what quality sir had. My lord, I will share a story with your lordship. That when sir came with a cycle, there was a person whose name is Padma, who distribute cause list. That hard copies used to distribute. I think your lordship hard time, the hard copies distribute from home to home. So this man, I think most of your lordships, they know Padma. So this man came on bicycle. One day, sir told me, one day he was crying in the corridor. Sir said, why you are crying? Because I lost my bicycle. Immediately, without hesitance, sir has given his bicycle. That this is bicycle, you take the cycle from me. From that day, sir was not bringing the cycle. So this is a story what sir told me. That I have given, he was crying, weeping, what I'll do, because he has to ride bicycle and he has to go to all the lawyers. Then I asked sir that from where you have done your schooling? He said that I have done my schooling from Jorhat. Thereafter, I pursued from Cotton College, graduation. Thereafter, I went back and I have done my law. Thereafter, I started practicing in Jorhat Bar and sir came in 1976. 76. I think I am not wrong, in 76. My lord, 2010, in the month of somewhere before Puja vacation, I was sitting in the court. somewhere in court number 7, that's the extreme corner of that building. Sir was in very good health. And also he had a good practice and he was doing regular second appeal. I asked sir, he told me that Diganta, I am not coming to the court from 2011. I asked him, why you are not coming? You are so good health. You have a roaring practice. You have regular second appeal. No, I thought of leaving the profession. He has given an example, your grandfather who was doyen of a criminal side, he left profession, good health. So now I decide I will not come to court from 2011. It's a fact, my lord, from 2011. 1st of January 2011, he never came to the court. So, my lord, this is what the legend, the doyen of our High Court. We miss him a lot. I'm missing him a lot. In fact, his son is with us, Tanmoy Mohanto, who is a senior advocate of this court. The same honesty and integrity he has like his father mine. I, and on behalf of myself and state of Mizoram and his people, offer a sincere condolence to the family of Mohanto sir and pray that his soul rest in peace.
Mr. B.D. Goswami, Additional Advocate General, Arunachal Pradesh.
Honorable Chief Justice and other honorable judges of Guwahati High Court, respected members of the registry, respected senior members of the bar, my colleagues and ladies and gentlemen present hearing. This indeed is another unfortunate occasion as we have congregated to mourn the sudden demise of late Durlabh Chandra Mohanto, senior advocate of this bar and an astute lawyer who left us for his heavenly abode on 20th of March 2023 after protracted illness. Born in 1932 in the Telpani Khotra, Koronga, Jorhat, which was a Vaishnavite institution in Upper Assam, late Durlabh Chandra Mohanto grew up in the Khatriya way of life. He was the son of late Mohan Chandra Mohanto, who was himself an advocate and a freedom fighter. After his primary education at Koronga, he did his Middle English schooling at Rongajan and then was admitted to Sankardev Seminary, Jorhat in class 8, for which he had to walk a distance of 12 miles every day to attend his classes. An ardent believer in communism, he joined the Communist Party of India at the tender age of 17 years in 1949. He was imprisoned for 2 months in March 1950 for his association with the communist movement. On his release, he was directed not to leave Jorhat town and to report to police periodically. This disturbed his studies, and for which he would complete his matriculation belatedly in 1950. He passed his ISc from JB College, Jorhat, and graduated from Cotton College in 1957. After his marriage in 1958, he went job hopping but gained experience in the industrial sector, particularly in ONGC Sibsagar. Thereafter, he took up teaching as a profession and joined Bedbury High School, Rongajan High School, and then Sinamora High School. Late Mohanto thereafter underwent BT course at BT College, Jorhat, and completing the same in 1961. All the while, late Mohanto continued his struggle for uplifting the lot of the working class, but also getting arrested in the process under the Defense of India rules, to be detained in Tejpur jail in August 1960. Late DC Mohanto graduated in law in November 1967 from the Law College at Jorhat. After enrolling in the Jorhat bar in 1968, he practiced there till July 1978, and then when he joined the Guwahati High Court bar. In recognition of his standing and service to the profession, late DC Mohanto was designated as senior advocate by Guwahati High Court in the year 1999. Paying heed to his inner passion, he left his profession in December 2010 at the height of a very successful professional career, only to pay more attention to his social commitments. He was intrinsically connected to the founding of his dream project of Sinamora College near his hometown, and he played an active role in its development. He was president of the governing body of the college on a number of occasions. Late Mohanto was also appointed the president of the Assam unit of the Indian People's Theatre Association, IPT. Late DC Mohanto was a very simple and hardworking person and a thorough gentleman with a straight face. His own requirements were few, but he didn't leave anything for himself to help all those who came to him in need. His demise has not only created a vacuum in the legal fraternity, but has also caused a great loss to the society. On his sad demise, I, on behalf of the state government of Arunachal Pradesh, its people, and on my personal behalf, express our profound grief and convey our heartfelt condolences to the members of the bereaved family, namely his wife, Srimati Kunu Mohanto, his son, Sri Tanmoy Jyoti Mohanto, a practicing senior lawyer of this bar, and his brother, Sri Dibya Jyoti Mohanto, an engineer working abroad. May his soul rest in peace. May his deeds continue to inspire us in the days to come.
Mr. Ranjit Kumar David Chaudhary, Deputy Solicitor General of India.
Honorable the Chief Justice, Guwahati High Court, honorable judges, members of the registry, senior advocates present here today, and my colleagues in the bar. We assemble here today to mourn the death of senior advocate, Mr. Dulab Chandra Mohanta. With the demise of Mohanta sir, I would say a strong pillar of the bar has fallen. It would take quite some time to find a replacement. The Lordship will agree that people come into this profession for various reasons. The primary reason would be for earning a livelihood, but there are some other reasons as well, which I would not like to go into. But here was a person who had come into the profession on his own volition to serve the people. By taking up cases of very poor persons, I, as an advocate, would say, let's say myself, I would demand some fees to keep my standard. This is my fees. If I've got this much of standing in the bar, this is my fees, you have to pay my fees, then I appear in your case. Here was a person who was never concerned with his fees. It was only service to the poor. Coming from a family of lawyers, though he initially started off as a teacher, then the profession got into him. He enrolled in the bar in 1968. And after a very long tenure in his profession, he left the profession at its height. I had a few occasions to interact with him, but the last time that I met him was around 6-7 months back. Sir was called for an interview in the television. I was also there. And the conviction with which he speaks is rarely found in other people. He was so convinced about the beliefs that he had held. In fact, after the interview, I went back home. I reflected upon what was deliberated. I felt so small in front of him. I felt like as if I'm a hypocrite, I cannot speak out. I felt so small in front of him. All that I can say is that he was an institution in himself. I hope his son, senior advocate, Mr. T.J. Mohanta, will take forward his legacy. I, on behalf of the Union of India and on my personal behalf, pray to the Almighty to give strength to the bereaved family to bear with this loss.
Ms. M. Kechi, Government Advocate, Nagaland.
My Lord Chief Justice, honorable judges, members of the registry, learned senior advocates, and my dear colleagues of this esteemed bar. We are gathered here today to offer condolence to the bereaved families of late Durlab Chandra Mohanto, senior advocate, who passed away on 20th March 2023. Sri DC Mohanto is a distinguished legal luminary of Guwahati High Court. Being a senior advocate, Mr. Mohanto truly did justice to his position and set an example for others. I've been told that Sri Mohanto provided legal services to the poor, needy, and marginalized people of the society and was a man of principle, compassion, and had vast knowledge in diverse subjects and impressively expressed his opinions in clear, unambiguous terms. He had a strong sense of value for justice. Today, I express my grief on the demise of Mr. Mohanto, whose departure has created a big vacuum in the legal fraternity. And today, on my personal behalf and on behalf of the government of Nagaland and the people of Nagaland, express my heartfelt condolence to the bereaved and grieving family. May his soul rest in peace.
Now, may we have the honor of reference by Honorable the Chief Justice.
My esteemed colleagues on the bench, Mr. Dilip Chaudhary, President Guwahati High Court Bar Association, Mr. Satyadhar Matak, President Guwahati High Court Advocates Association, Mr. Chinmoy Chaudhary, Chairman Bar Council of Assam, Nagaland, Mizoram, Arunachal Pradesh and Sikkim, Mr. Dilip Majumdar, Additional Advocate General Assam, Mr. Diganta Das, Advocate General Mizoram, Mr. B.D. Goswami, Additional Advocate General Arunachal Pradesh, Mr. R.K. Dev Chaudhary, Deputy Solicitor General of India, Ms. M. Kechi, Government Advocate Nagaland, learned senior advocates, members of the bar and registry. Today, we have assembled here to mourn the sad demise of senior advocate Shri Durlab Chand Mahanta, a member of the Guwahati High Court Bar Association, who left for heavenly abode on 20th March 2023. Late Shri Mahanta was born in the year 1932 at Telpani, Satra, Karanga, Jorat. After completing his primary education at Karanga, he got admitted to the Shankardev Seminary, Jorat, in class 8th. After completing his matriculation in the year 1952, late Shri Mahanta graduated from the Cotton College in the year 1957, and thereafter he served in different institutions like Karanga Village Industry, ONGC. He also served as a teacher in the Betbari High School, Rangajan High School, and Sinnamara High School. Late Shri Mahanta completed his law from Jorat Law College in 1967 and joined the Jorat Bar in 1968. Thereafter, he shifted his practice to Guwahati and joined the Guwahati High Court. Recognizing his outstanding practice in the bar, late Shri Mahanta was designated as a senior advocate in the year 1999. Shri Mahanta, apart from pursuing a career in teaching and law, had a keen interest in the upliftment of the members of downtrodden sections of society. With this objective, at the early age of 17 years, he joined the Communist Party of India in 1949 and was an active member from 1964 to 1975. He was imprisoned for his relentless struggle for the mass people of downtrodden section. I'm told that late Shri Mahanta has written books on various subjects and was engaged with the various socio-cultural and educational organizations. He was also the advisor to the Communist Party of India, Assam State Council, Department of Party Education, Party's Mass Communication, Kisan and Cultural Organization Party, and editor of the journal Janmat. Late Shri Mahanta was also actively involved in the trade union struggle as the Assistant Secretary of the AITUC Assam branch. Although I did not have the opportunity to meet late Shri Mahanta personally, but I'm told that he was loved and respected by all for his compassionate attitude, honesty, his zeal to work for the poor and needy, and for his fair submissions in the court. I'm told that late Shri Mahanta is recognized for his honest, courageous, and straightforward arguments at the bar. Recognizing his contribution to the bar, he was felicitated by the Guwahati High Court on completion of 50 years of practice as an advocate. His death is a great loss, not only to the respective family, but also to the legal fraternity, and cannot be fulfilled. Late Shri Mahanta leaves behind his wife, 2 sons, one of whom is a senior advocate of the Guwahati High Court, Sri Tanmay Jyoti Mohanta, who takes the legacy of his father, late Sri DC Mohanta, forward and is just as sincere and passionate as his father. I and my brother and sister judges on the bench fully associate with the sentiments and feelings expressed by the members of the bar. I, on behalf of my esteemed colleagues on the bench, on my own behalf and the members of the registry, convey our heartfelt condolence to the members of the bereaved family and pray to the Almighty to grant eternal peace to the departed soul and give sufficient strength and courage to the members of the family to bear the irreparable loss. As a mark of respect to the departed soul, I request the learned members of the bar and bench to observe a minute's silence.
Time.
The court work on the judicial side will remain suspended for the rest of the day as a mark of respect to the departed soul. The registry shall communicate the proceedings and convey our heartfelt condolence to the members of the bereaved family.